the DWLS if we set up a payment plan for the December rent.
Okay. It's good to see you, Mr. Remy.
Good seeing you.
Doing good work.
Thanks. How are you doing?
Doing well. I've been sending all kinds of people your information, so I hope you're keeping busy.
I am. Thank you.
All right. This is 2122430T, the People versus Asia Williams Trammell.
And good morning, Your Honor. Matthew Zick for the People.
Good morning, Your Honor. George Ramey for the defendant.
All right. So I know the two of you've had a chance to pre-try this, Mr. Zick.
Yes, good morning, Your Honor. We've had an opportunity to speak. At this time, people are moving for dismissal of the driving while license suspended charge. It's my understanding that the defendant will be tendering a payment plan to the court on the 3 outstanding civil infractions.
All right, that's great. So let me see here a total of what she owes on those. Does she have other matters you're representing her on, Mr. Remy? How's it going?
Yes, Your Honor. So we've taken care of, this is the last open case. We just have suspensions, 3 suspensions with this court, 24th and 25th. So we should be able to work out a payment plan and come up with as much funds as we can to hopefully clear up all of those suspensions here in the next few weeks.
Great. So the misdemeanors dismissed. And then we have these 3 civil infractions. I have a total on all of them of $961. Does she have payment plans at other courts?
Not yet, Your Honor.
Okay.
And so we should be able to, is there any way she can pay the clearances first part of the payment plan? So that way, once the clearances are paid, she'll be able to get her license back and then keep making the payments?
Yes. So I'll tell them to put the first payment for the clearance fees. And then, Ms. Williams-Trammell, what can you realistically, I mean, the goal here is to help you get your license back. So
yes, ma'am.
Don't overshoot it. Tell me what you can pay on a monthly basis. Tell me what's realistic for you.
Well, I started a new job. I started my new job last week, and I'm start getting paid on the 3rd. So from the 3rd, I can pay $150 each week on Friday.
No, I'm gonna have you pay $100. Let's start like this. You got kids?
No, I don't have kids.
Okay. Do you have a vehicle once you get your license reinstated?
My boyfriend got a vehicle, but we don't drive until we get our license. Like I can Uber.
Okay. I'm gonna give you a payment plan of $150 a month. Okay?
Yes,
that's
ma'am.
realistic. You'll be paying a little longer, and if you can pay it off sooner, if you can afford to pay $150 a week, that's great. But I don't want to set you up to fail.
Yes, ma'am.
And that's a lot of money, and I'm guessing you have bills. So we'll do $150 a month.
Yes, ma'am.
And almost the majority of this is late fees. So if you pay $650 off, I'll waive the balance, okay?
Yes, ma'am.
So I'll knock off a lot of those late fees for you and kind of return them back to what they should have been. Because I want to see you be successful and get out of the hole. And I know you're working with an attorney, and that's what he's doing. So you make your payments, and when you get to $650, the court will send you something. And if you're not sure, call the court and just make sure the rest has been waived, okay?
Yes, ma'am.
All right, good luck. You're all set, ma'am.
Thank you so
Your
much.
Honor.
Back door. Thank you. And then I've got, do I need Mr. Check out here? Oh, there he is.
I'm right here.
All right, good morning. This is 2516820T, the People versus David Check.
Good morning, Your Honor. Jeffrey Phantom on behalf of Mr. Checkway. Formal reading, stand mute. Mr. Check's going to plead guilty to the admitted charge of failure to display a valid operator's license. He paid the civil infraction in full. We're requesting 30 days to pay.
All right, Mr. Check, can you tell me your first and last name?
David Matthew Check.
All right, Mr. Check, Failure to display is, I entered a not guilty plea for purposes of arraignment. Failure to display is still a misdemeanor. It's punishable by up to 90 days in jail and a fine of up to $100 plus court costs and statutory fees. Do you understand that, sir?
Yes, ma'am.
Okay. And did you go over your constitutional rights with your attorney? They're outlined on this advice of rights form.
Yes, ma'am.
Did you understand your rights?
I do.
And did you give your attorney permission to sign your name on this advice of rights form?
I did.
Okay, you understand, sir, if you enter a plea of guilty, you'll be waiving the trial rights listed on this form. There will be no trial of any kind.
I do.
And you understand if you're currently on probation or parole and you enter a plea of guilty, it could be a violation of your conditions.
I am not on parole or probation.
All right, and if you're not a citizen and you enter a plea, it could have immigration consequences up to deportation. You understand that?
I am a citizen of the United States, born and raised here.
Okay, sir, knowing all of that, how do you plead to the charge of failing to display a valid license? Guilty or not guilty?
Guilty.
Has anyone forced you to get you to plea?
No, ma'am.
Has anyone promised you anything other than the plea agreement to get you to plea?
No, ma'am.
Are you pleading guilty of your own free will?
I am.
Sir, were you operating a motor vehicle in the city of Taylor on June 3rd of 2025?
I was.
And while you were operating that motor vehicle, were you let me strike that. Did you get pulled over by a police officer for some sort of ticketable offense?
I did.
And did that officer ask you to produce a valid license?
He did.
And did you
Actually,
fail to do so?
Yes, correct.
You failed to display one?
Yes.
All right, are you satisfied, Mr. Fanto?
Yes, Your Honor, thank you.
All right, I'll accept the plea as knowing and voluntarily given. Sir, you have a fine of $200, court costs of $100, crime victims' rights fee is $75, and a state assessment of $50. That's a total of $425. And you'll have 30 days to pay. And if you need any longer, call the court and let us know, okay?
Okay. Where do I send the payment? To the
You
court?
can look on your notice to appear and it'll give you the address and everything for the court on there. You see up at the top, it'll tell you. So you can
Okay.
mail it there, or you can go online to the 23rd District Court's website. And you can pay electronically that way as well.
That'd be perfect. Thank you.
All right, you're all set, sir.
Thank you.
Thank you, Your
Have a
Honor.
great day.
Yeah.
You're not to go back to two.
And
Where was he? Why didn't he show up? 7?
for the record, James Sparrow, P57197 on behalf of Mr. Faust, since the time and date set for trial course.
Good morning. Your name, sir? Where was he? Why didn't he show up?
Your Honor, what happened is, and as you see from the nature of the charge, his driving while license expired. He had a friend that was going to pick him up. His friend called and told him he was running late. My client did call the court right around the time he was supposed to be here. And the court basically told him, that they would either get back to him or give him another date. He called me later that day. I saw that this was in the system and then he retained me.
All right, so does he stand mute, wait formal reading?
Yes, Your Honor.
Flat Rock's here today, aren't they, Heather?
Yes, I've already talked about her, and we're just waiting on the file to go back in.
Okay, I'll enter a not guilty plea. $100 personal bond. You cannot leave the state without the consent of the court or violate a law. You must appear in court as directed. We'll give you that. Take to the prosecutor and then let me know when you're ready.
We'll see you in a few.
Thank you. Higgins. Ashley Michelle Higgins, 26B 82699A and B and C.
This is the point.
Your name? You have an animal violation, vicious dog. You have 2 civil infractions, dog roaming at large and license, no dog license. You have the right to an attorney. If you would like one, I will give you one. Do you want an attorney?
Yeah.
All right. So I'll arraign you and then I will send you to the prosecutor, okay? So you have 1 misdemeanor, vicious act. It is alleged that on January 18th of 26 that you had a dog that was on Racco near Relda in Brownstown and it attacked another dog. That is a misdemeanor punishable by up to 500 fines, 90 days jail, costs, or all of those penalties. Do you understand that? Yep. Did you sign, read, and understand this advice of rights form? If you plead guilty, you will be giving up all those rights on the advice of rights, and there will not be a hearing or a trial of any kind. You understand that? You got to keep your voice up.
Oh, yeah.
All right. You still have the 2 civil infractions, no dog license and dog at large.
And I did get the license for the dogs.
Okay. So I'm going to enter a plea of denial on those. What kind of dog is this?
Siberian.
Okay, you got to keep your voice up.
Siberian.
Okay. All right.
And my neighbor, I don't know if it's you that I speak with, but my neighbor did say that she was trying to drop the charges. So she did write a letter to me, and I think was going to talk to the prosecutor about it.
I don't have anything to do with that. Your dog is to be in a fenced-in yard or on a leash, equipped with a muzzle, and accompanied by a suitable adult. Do you understand that? Or inside your residence. Okay?
Yeah.
Also, again, you cannot leave the state without consent or violate a law, and you must appear in court as directed. You go out in the hall, he's taking the file to the prosecutor, you sign in out there, and the prosecutor will call you, okay? Good luck. Either way, you're coming back in front of me. Nevin Todd Janot, 26R514412. Your name, sir? You're charged with super drunk and you have the right to a lawyer. You want a lawyer?
Yes.
All right, John set him up with an attorney. You can go out in the hallway and we will set you up. Okay?
Yes, sir.
Either way, you're coming back in front of me. Thank you. Emma Swade? Two 6R514500. Good morning, ma'am. Your name?
Good morning, Emma Sweat.
Okay, so you met with the department rep, the Officer Hirschberger, it looks like, and you two agreed that you would plead responsible for impeding traffic with the speeding to be dismissed, true? To that charge of impeding, responsible or not responsible?
Responsible.
Plea is accepted, speeds dismissed, 150 is your total. Yes, you're into the hall to your right and you're all set.
Thank you.
Good luck. All right, people against Castro. Jose Felix Aaron Castro, 19F 231230. Your name.
Jose Castro.
All right. Mr. Castro, I don't believe you had an attorney before, did you, sir?
No, sir.
All right, so you pled guilty under section 771.1 to retail fraud. And the agreement was that it would be taken under that statute for a period of 3 months. They dismissed the retail fraud at the time of the plea. All that's true, correct?
Yes.
I did not order a pre-sentence report or any kind of screening. I just set it for hearing, for sentencing, I should say. And that's it. So you have the right to a lawyer. If you want one, I will give you one.
No, sir.
You waive your right to a lawyer?
Yes.
Okay. Is there anything that you would like to tell me before I sentence you?
No, I mean, I haven't been in trouble, don't plan on being in trouble with a mistake I should have never done. I did it. I apologize for it.
3 months probation, I'll take it under section 771.1. You cannot leave the state without consent of the court. You cannot violate any law or ordinance. You cannot enter any Meijer store in the next 3 months. You must report to probation as directed. You're not to go back to 26100 Vreeland in Flat Rock specifically, but you're not going to any Meijer store. Do we understand that?
Yes, sir.
All right. Fines are 150, costs are 100, 75 victims' rights fee, $50 justice assessment. So, and $60 in probation fees. So your total here amounts to $310 plus your 125 for 435. I'm going to order 4 hours of community service. You're to complete that in this case no later than April the 1st. Okay?
Okay.
I'll give you a review hearing date. So again, you owe the court $435. Do you have all that?
I didn't.
All right. So you'll pay that.
He did have a bond too, Judge.
Yes, you have a bond of $300, which is in your name. So that was, let's see, that was 3,010% by law. We keep 10%. So you have 270 to apply. So you'll apply the bond, you'll go down, you'll pay the other 165.
Okay.
John, see if probation needs to see him, if nothing else, to explain the community service. But you have to do community service 4 hours by April 1. You can do that at any nonprofit organization of your choosing. This church, Salvation Army, St. Vincent de Paul, I could care less. It doesn't matter, but it has to be nonprofit.
Okay.
We're going to give you a review hearing date, 3 months. You'll come back. If you've done everything and stayed out of trouble, the case will be dismissed on motion to the prosecutor.
Okay.
So we need one for May sometime
May 14th.
at 8:30, May 14th at 8:30. So you'll go down the hall, pay your fines, apply your bond, get your notice, your paper notice.
Okay.
Then you'll go meet with probation. Good luck.
Thank you.
No more though, okay? You ready, Jack? Mr. Sparrow? Yeah, just hand it to Sadie.
So you gotta go to probation.
Okay.
But you're gonna go down and take care of the other business first, okay? People against Charles Faust. Charles Anthony Faust, 260-245-377. Mr. Sparrow?
Once again, Your Honor, for the record, James Sparrow, P57197, on behalf of District Faust in this matter.
Sir, your name?
Charles Faust.
All right, so you met with the prosecutor. He's going to dismiss the expired license, and your client's going to plead to allowing an unlicensed driver to drive, true?
That is correct.
That is punishable, sir, by up to 500 fines, 90 days jail, costs are all those. But there is no reporting to the Secretary of State, 0 points, no, non-abstractable. Do you understand that?
Yeah.
And did you sign, read, and understand the advice of rights form here today?
Okay. Yes.
If you plead guilty, you'll be giving up all those rights and there will not be a hearing or a trial. Do you understand that?
Yes.
All right. And this is how you wish to proceed?
Yeah.
All right. To that charge, allowing an unlicensed driver to drive, how do you plead?
Yeah.
Guilty.
On January 7 of 26, were you in control of a 2011 Chevy that was being operated on Telegraph at Ypsilanti?
Yeah.
Senator,
He's very nervous, Your Honor.
well, there's no reason to be nervous.
I'm not used to this. Sorry.
It's all right. Were you in control of that 2011 Chevy that was being operated on that date of January 7th of 26 on Telegraph in Ypsilanti and Flat Rock?
Yes, sir.
And you were suspended and knew it at the time? Is that true? Or unlicensed, I should say?
Yes, sir.
Are you on probation or parole?
No.
Anybody force you to plead guilty? Please accept it. This expired license is dismissed. Anything you'd like to say?
Yeah, I can say, my client owns his own business. He does detailing, mobile detailing for predominantly RVs and boats. He has a bunch of work when the weather breaks. He can't do it until then because it won't take. He would just ask for 30 days for fines from us.
20, anything you'd like to say?
No, sir.
25 fines, 20 costs, 75 victims rates, $50 justice assessment. He has a valid registration now, right? You got a valid, you renewed your license, right?
Your Honor, and I discussed this with Mr. Kalen. When he gets money, he's getting all that set too. Your Honor, he does really, really well in the summer. Unfortunately,
Maybe-
speaking with him, he's really not good at it.
How'd you get here today? You didn't drive, right?
Your Honor, his friends waiting in the parking lot. I know the gentleman that drove him. And that's why he missed last week.
March 17th, you pay by.
Thank
If you don't have the money by March 17th, you call the court, we'll go on Zoom, I'll give you an extension. You gotta save your money or do something. You can't drive around without a valid license, okay? Best of luck. Higgins, thank you.
Good day.
Okay. People against Ashley, Michelle Higgins. This is 26B 82699 A, B, and C. Your name?
Higgins?
Did the victim's dog seek vet treatment?
I wrote, she said the injuries were very minor.
All right, so the prosecutor wrote this up. So Heather, we're gonna take out everything I just ordered because there's not a misdemeanor charge here anymore. The prosecutor is dismissing the vicious act charge, so there's no misdemeanor. She's pleading to the 2 civil infractions, and the prosecutor moves to dismiss as defendant has taken collective action to ensure this does not happen again, and complainant does not wish to proceed with charges, which is what you told me. So all I'm going to do is, so Heather, I enunciated all those bond conditions. I just want to make sure that they're not reflected anywhere. And then I'm going to take these pleas and fine you on the other 2.
Okay.
So you understand everything?
Yeah.
All right. To the charge, dog at large, respond. You got to take the phone out of here, please.
Phone's gotta go.
Phone out of the building.
Out of the building. Did your phone just go off?
Somebody's did.
Somebody's phone, huh?
To the charge, a dog at large, respond. Hang on, ma'am, can you just keep your voice down a little bit for me, please? Dog at large, responsible or not responsible?
Responsible.
No license. You got to keep your voice down. No license. How do you plead to that? Responsible or not responsible?
Responsible.
Sadie, can you bring her tickets up for me? Can you? Okay, I'm accepting those pleas. I'm dismissing the dog at large. I don't remember what our cost is on those, Heather. Can you tell me?
135 apiece, Judge.
All right, that's good. Thank you. Fines and costs of 135 on each. Can you pay all that today?
Yes.
All right. Good luck to you. Wish you well. Have a great day. 270, 135 each. Yes. Good morning.
Hi, Judge.
How are you?
Good, how are you?
Very good, thanks.
Did you want that up?
I don't need it anymore. I'm sorry. Morning. Look like you're taking a leisurely stroll. Coffee in hand. And no pressure here. People against Brian Keith Walker. 2-6R-514484.
Good morning, Judge. The apathy will be 82378 on behalf of Mr. Brian Walker, decision maker.
Brian Keith Walker.
All right, so we moved this sentencing. The fact that pled guilty previously to operating while impaired, the drunk driving or operating while intoxicated was dismissed. He was referred for a screening and assessment. Did you have the opportunity to review the report with him? And are there any material additions, corrections, or deletions?
We have reviewed the report. There are no additions, deletions, or corrections.
Okay, anything that you would like to say?
Your Honor, just that he has been employed at Rating Plus for over a year. His children are 14 years old, 3 years old, and 8 months old. He's apologetic for the situation. He's looking forward to, I know the drug impact panel is something that's ordered. I've heard from a lot of the clients that they really enjoyed that. It taught them a lot. So other than that, Your Honor, I would ask that you follow probation's recommendation.
Anything you would like to say?
No, sir.
He's got a lot of warrants, so
We discussed those two, Judge.
why are you doing that?
Just recently, I didn't know about it. Yeah, so I'm gonna take care of them as soon as possible, as soon as I hear.
You didn't know about it.
Yeah, I had
Be careful now. Just be careful.
Yeah.
Okay? I don't want to hear stories. Okay? Don't tell me you didn't know about it. I mean, the court never notified you. You didn't have tickets handed to you. You thought they threw them in the garbage. What?
No, I'm pretty sure it's because I moved. And I never changed my address.
You got a high breathalyzer and you scored high on the alcohol use portion. Show your lawyer the AA verification.
Sure, what?
The AA verification. I ordered you to go to AA. So I just want you to know what concerns me there.
No, they didn't give me any place or any big deal.
You had the sheet, but it was blank, Your Honor.
Yeah,
Because you didn't go.
so I wasn't scheduled.
I told you to go to AA. You weren't listening?
No, I was.
Well, where did you go to AA? Look at
I
me.
was getting my sentence thing, and they didn't.
You thought I was telling you what the sentence was going to be?
So, Your Honor, we did discuss that, but he thought all of that started after he was actually sentenced, Judge.
I didn't know I was supposed to. I really didn't know. Right.
Well, he knew about it. He just thought he had to start going after the day of sentence.
Makes me want to put my glasses on upside down. You know that? I told you, look at me. Stop looking at your unsigned papers there. You have to follow the orders of the court. You scored in category 5 on both the alcohol and drug use portion. And that tells me you got a real problem. It's okay, but you're going to deal with it or this is not going to work nicely for you.
Yeah.
So I want to make sure that we understand one another going forward. I'm going to let this go, but you're going to comply with orders or we're not going to get along.
I want to.
Why would I have had him give you the AA sheet if you want to talk about this at that time if you weren't supposed to start going to AA until sentencing?
Because the guy that I met with first.
Who's the guy?
I don't know.
Is it a lawyer?
Yeah. One of the lawyers in the office. he was explaining to me that they had to give me the location of where I'm going to be. And he was like, when he talks to the probation.
What lawyer? I don't want to know. I don't want to know. Listen. You scored in category 5. I cannot emphasize that enough. 13 months probation. You cannot leave the state without the consent of the court. You cannot violate any law or ordinance of any unit of government if you change your address, your place of employment, or home telephone number. You must notify probation. You have to report as directed. No alcohol, no marijuana, no illegal drugs. You're not to purchase, possess, or consume any one of those. Kratom, poppy seeds, and CBD oils are prohibited. Consuming food or other items containing those substances will be deemed a violation. You're to submit to chemical testing, PDTs, and ETGs. I'm going to make it bi-weekly for 4 months. If you're clean, I'll revert it to monthly. Attend AANA at least twice a week in person. Just listen. You have to go in person. You have to have your AA verification form seen. Every time you come to court, you have to bring that form with you, whether it's in front of me or to the probation department before you report it. You understand that? You're going to be going to AA twice a week. I'm ordering intensive outpatient treatment with aftercare. You need to go to that. Once you start intensive outpatient treatment, that's going to keep your hands, it's going to keep you busy. You don't have to go to AA or NA anymore, unless it's recommended as aftercare. Do you understand that?
Yes.
You're also to attend the Victims Impact Panel, which is one night put on by Mothers Against Drunk Drivers. 4 days jail, credit 1, serve 3. I'll let you serve those on the court work program. But you're going to have to get here and don't be late. Do you understand what I'm telling you? There's 3 days court work. There's a $35 a day charge for that for a total of $105. Pay fines $300, cost $200. $75 victims' rights fee, $50 justice assessment. So fines and costs are $6 1/4. You have to pay $260 in probation fees, bringing your total to $885. You have cost of recovery of $150, bringing your total to $1,035. Plus your court work program fees. Everything included amounts to $1,140. If you violate, your probation could be revoked, you could be incarcerated for up to 93 days. You may be eligible for early discharge. You get all this done in 6.5 months with no violations, I'll be happy to discharge you early. Probation will explain that to you as well. You're to clear all of your warrants. I'm only giving you until March 17th. So you're going to clear all your warrants by March the 17th. You understand me?
Can I add something? Do you mind if I get longer?
Why? Why?
It'll be, I'm trying to keep up. That's it.
You make $600 a week. How much do you make? And you get a bridge card of $391, right?
Yeah.
Well, $600 a week. How many hours do you work?
Only work 8 hours. I mean, 40 hours. $40.
They pay you $15 an hour. Is it before tax, 600, or after tax?
Yeah.
So you make what, about 18 or 20?
Yeah.
I'll give you until April 17th. That's it.
Thank you.
Judge, can I ask you what your total was again? I believe I'm off on what you got.
Sure. Let me repeat it. You'll clear all your warrants. That doesn't mean that if you get stopped, you're not going to get picked up and taken into custody.
No, I just want to
You got it, what I'm saying? So don't read this as me saying it's okay not to take care of it. If I were you, I'd be running to the courthouse and explaining to the judge. But that's me. All right, let me just double check it. 6 1/4, 685, 885, 945, 1,095. Yeah, you're right. It should be. Yeah, am I right that it should be 1220?
I think I might be missing something then.
I have $60 screening fee.
Mhm.
I have 75 and 50 on the Victims' Rights and Justice Assessment, 300 fines, 200 costs, 260 probation fees, cost of recovery of 150, and court work program fees of 105.
I missed the cost recovery. I have 1,200 with a cost recovery of 150. That was the only thing I was missing.
Hang on a second. I'm sorry.
No, you're okay. I just like to make sure we match.
85, 885, 945, 1,095. Yeah, it should be 1,200. Is that what you got?
Yes, that's what I have. We're good now. Okay.
Can you pay all this today? You gotta work harder. Did you? You got an associate's degree. I don't know why you're only working for $18 an hour. You graduated high school, you got an associate's degree, right?
Yeah, but it was for studio audio engineering.
How much can you pay per week or per bi-weekly, whatever you want? I'll set you up on a payment plan. Does he have anything today?
No, Your Honor.
But you got enough to, how much can you pay weekly or bi-weekly?
Bi-weekly. 200.
I don't need you to do two. Do $100 bi-weekly. And I will start this beginning on March the 6th. If you ever don't have the money, you call the court. We'll go on Zoom. I'll be glad to give you an extension. Don't ignore me though. Are you listening to what I'm telling you? All right. Show some respect for the system. I fail to believe that I didn't thoroughly, clearly enunciate that you were to go to AA. Good luck. You'll meet with probation. Have a good day. Are we ready on the intel?
Thank you, Judge. Yes.
Corey Elizabeth Antel, file number 25F245326.
Good morning, Your Honor. Bianca TOP 82378 on behalf of Tori Antil, Station.
Tori Elizabeth Antel.
Good morning. All right, so counsel, your client here pleaded guilty to operating while impaired. It was agreed upon cost of recovery of 150. The good news is she scored in category 1. I can't go along with 8 months, or 6 months, but I will recognize that she shows, at least according to the test, that she shows no evidence of alcohol or drug serious abuse. So I will take that into account. Have you had a chance to review the report?
Yes.
And are there any material additions, corrections, or deletions?
We have read the report. There are no additions, deletions, or corrections.
Anything you would like to say on her behalf?
Yeah, she's been employed at DoorDash for a couple months. She just got hired at Amazon. She doesn't have a good work history. Prior to that, she was employed at Taylor Four-Wheel for 2 years. She doesn't have any children, Your Honor. And I would just ask that you follow probation's recommendation.
Anything you would like to say?
No, Your Honor.
I'm going to go 8 months probation. You'll be eligible for early discharge after 4 if you complete everything. You cannot leave the state without the consent of the court or violate any law or ordinance. If you change your address, place of employment, or home telephone number, you must notify probation. You have to report as directed. No alcohol, no illegal drugs, no marijuana. I'll say the testing is only going to be on demand. Probation, kratom, poppy seeds, and CBD oils are prohibited. Consuming food or other items containing those substances will be deemed a violation. I'll go along with the level 1 alcohol education program and the victims impact panel, 3-day scale, credit 1, serve 2. I'll let you serve those by way of community service. So 16 hours of community service. And you have to do that again by April the 1st. Fines $300, cost $225, 75 victims' rights fee, $50 justice assessment. That's $650. Your screening fees 60 for 710. Probation fees are $160 for 870. Your cost of recovery is $150. Your total is $1,020. If you violate, your probation could be revoked. You could be incarcerated for 93 days. You'll have 21 days to appeal, 14 days to apply for a court-appointed lawyer for purposes of appeal. You understand all that?
Yes.
And again, you can be eligible for early discharge if you do everything, okay? Does she, What about the money situation? Can all this be paid today?
No, she needs to pay it right now.
All right. It should come with some money here. How much can you pay weekly or bi-weekly?
Could do 100 bi-weekly.
I'll let you do 60 bi-weekly. And I'll start that beginning on March the 6th. If you don't have the money, no problem. Call the court. We'll go on Zoom. I'll be glad to give you an extension. Okay? All right. You'll meet with probation before you leave. Good luck.
Thank you, Judge.
Do you have Urban?
I do.
Galea, May Irwin, 26R254917. And I also have this other file that was dismissed that there's going to be restitution on 26R254918. But that one should be closed. I just need, the only question I have is, well, everybody state their appearance, please.
Deanna Patillo, 82378 on behalf of Ms. Leah Erda.
It's Galia, but Galia, we're close.
What happened is that there were,
Yeah, sorry.
that's okay, there were 2 destruction of property charges. And the plea agreement reflected that she was going to pay the restitution of $245 and then $279.97. $279.97 is on the dismissed case, 918. I don't have a problem going along with that. But she's going to be paying through the court restitution. Oh, I just want to double check one thing before I go on. She's going to pay restitution on, I believe, 918 in the amount of $279.97. And that is going to be paid through the court for victim Sierra Rose. Okay? Or Sierra Davis, rather. Sierra Davis. And then she's going to pay $245 on file 917, ending in 5917, on Tara Brewer. That is all going to be paid through the court. So the agreement was that she'd plead, it would be taken under 771.1. Is there any need for her to have any contact with any of these victims?
No, Your Honor.
This was silly. You guys were friends?
Yes, Your Honor.
I mean, this is kind of quite a temper tantrum, I think. They didn't take you where you wanted to go. You wanted to go to someplace else. They didn't. And then you went over and damaged their property. That's crazy.
Well, I was just, I mean, there's absolutely no excuse here.
I know.
I was just trying to get home with the kid. That's all. I didn't want to get in the car with them. They were intoxicated. They were acting full of themselves. And I just did not feel comfortable. I should not have gotten angry. I have 2 kids that I have to think about, and I did not think about that.
All right. Is everything in this report accurate?
It is, Your Honor. We reviewed the report. There are no additions to our correction.
All right. Anything that you would like to say? You guys were all under the influence, so correct?
I mean, like I said, I only had the 1 drink. I was not intoxicated like that, but they had multiple drinks at the bar.
You also had prescriptions, so
I have prescriptions, yes.
that tend to exacerbate the effects of 1 drink, right? Let's just move on. Anything you'd like to say? First of all, everything in the report is accurate?
It is, Your Honor. Just like she stated, she has 2 children. She has been employed for 2.5 years. She is very apologetic for this situation, Judge. So I just would ask that you adopt probation's recommendation.
Nan, what would you like to tell me?
Me,
Anything.
So,
You don't have to tell me anything if you don't want.
well, my situation is I really only have, like a sitter for work, and it's my mother. She's, older and has a lot going on. So it's very hard for me to, get out of the house, which is why I got out that weekend. That was a first in a long time. Definitely not doing it again. But it's very hard for me to get out. I know that if I'm on probation, it's going to be very hard for me to show up because I'm not going to have sitters. So like I said, I'm just trying to work something out. That's all I have to say.
Sounds like you're setting yourself up to fail. You're going to have to show up for probation.
Well, then I'm going to have to bring my children. If that's cool with you, that's okay with me.
They'll let you Zoom if you explain that to them. I'm sure they'll let you Zoom. Nobody's trying to make this difficult for you,
Of course,
but not good. All right, 6 months probation. There was no designated, I don't know if all this is necessary. 6 months probation. You cannot leave the state without the consent of the court or violate any law or ordinance. You change your address or place of employment or home telephone number. You have to notify probation. You have to report as directed. No alcohol, no marijuana, no illegal drugs. Kratom, poppy seeds, and CBD oils are prohibited. Consuming food or other items containing those substances will be deemed a violation. You receive chemical testing, PBTs, and ETGs. I'm going to make that on demand. You're to attend an impulse control class. I'm not going to order this drug insight class. No contact with Sierra Davis. By the way, is Sierra Davis or Tara Brewer here or on Zoom, Heather?
Not on Zoom, Judge.
So you're not to have any contact with those two victims at all. No contact with Sierra Davis and or Tara Brewer. You cannot write, phone, see, text, email, or communicate with them or have anybody else do any of those things for you or on your behalf. You have to pay restitution through the court. And I'm putting this on the bottom. When you look, they'll give you a copy of this order. But this is through the court. You're going to pay this $279.97, which will be designated for Sierra Davis, and $245 for Tara Brewer. So those two sums, they should come out $479. Should be, run that math, it should be $524.97 in restitution. Is that right? So 470 or 279.97 plus 245. So
Did you say 524.97, Judge?
Correct.
Yes. And are we putting that all on one case, or am I keeping the one-on-one case?
I can't really assess restitution on a case where it's been dismissed. I have no authority to do that. I wish they wouldn't do it this way. But I'm going to have to put them both on 917, and that's why it's becoming more complicated here. But if I order it on a dismissed case and she doesn't comply, I've got no authority to do anything except tell her they made a mistake. So that's it. 100 fines, 125 costs, 75 victims' rights, $50 justice assessment. So your fines and costs here amount to $350. Screening fee is $60 for 410. Probation fees are $120 for 530. And then you have the restitution. And the restitution will make this be $1,054.97. I'm not going to order the court work program. I won't do that. But this was silly. She was not taken into custody this night, correct? She was never in custody on this, correct?
No.
3 days community service. I'll given everything till April 25th. Okay. So do you understand the sentence of the court? I am taking it under section 771.1. We'll give you a review hearing date. That should be in early August, Heather. And you're compliant. Prosecutor will move to dismiss. You look like you got punched in the gut or something. What's wrong?
No, I'm sorry. I didn't look like I didn't.
Your Honor, does it need to be in the order that you're okay with her appearing on Zoom for the probation?
Yeah, well, they're gonna let her do that. If they tell you they won't, then you come back in here and I'll talk to them. I don't need to gum that up. They let people appear on Zoom all the time, I think. Don't they, Heather, or am I just starting here? I think
No,
they do.
as far as I know, they do.
All right, they do. You'll be fine.
Judge, for the review date, we have Rockwood either August 6th or August 20th.
We'll make it August 20th at 8:30, man. Oh, that's too late. That's more than 6 months. I'm gonna have to make it the 6th. Today's the 19th, right?
Yeah.
August 6th at 8:30, ma'am. Now,
Yes,
you understand the sentence.
yes, sir.
So I'm not gonna make you do the court work program. I'm not gonna make you do the drug insight. You tell me how much you can pay today and how much you can pay weekly or bi-weekly, or tell your lawyer, however you want to do it.
I will pay 100 today
Okay?
and I can do bi-weekly 100,
You sure? You got 2 kids.
maybe 50. Maybe 50 bi-weekly.
Is the father in their life?
No, none.
What is wrong with these guys?
I just know how to pick them, I guess, Your Honor.
Well, I mean, I don't get it. I don't, the single biggest, most important thing we do is parent. And they have kids and then they never see them. And we wonder why our society's messed up. $50 bi-weekly. I'll start you March 6th. Is that good?
That's beautiful. Thank you.
If you don't have the money, there's no reason to be scared. We call the court. We'll go on Zoom. I'll be glad to give you an extension. Just don't ignore me or I'm not going to be nice about it. Okay? You'll meet with probation. Good luck. Thank you.
Thank you, Judge.
Thanks a lot, Mr. Teo. William Edward Miller, the 4th. 26R514439A. Joseph Lyon, have a seat up at the table. Mr. Miller, come on up to the podium. Mr. Miller, your name?
Morning, Your Honor. Miller.
Good. You?
Great.
I don't know what happened here, Heather. I'm trying to. What is your date of birth?
July 7, 2006.
Yeah, okay. Heather, I don't know what happened, but you were here but left.
So last time I was here, we went through the first hearing, and then you sent me to the prosecutor.
Yeah.
And then I had to go pick up my son, and there was a couple of people ahead of me. And you said,
Okay. Good enough. Did you have a lawyer?
no.
Okay, so if you're waiving the right to a lawyer, I'm going to call them and tell them you were waiting around too long, and I want them to take this first. Okay, is that all right with you? All right, hang on one second. Jeez. Mr. Pellin, can you walk in the courtroom here real quick?
Yeah.
Thank you. Thank you. So just wait right there and I'm going to hand him this case, okay? And then we'll go from there. You're only charged with no operator's license on your person. Not that that isn't. You did have a civil infraction. Did he go into default on that?
Those, the other two were dismissed, I'm pretty sure.
Well, see, I said something about a stick form was something. I can't even read my own writing, Heather. Rescheduled case, stick form was something.
And on the B charge for this one judge, he paid that one, the speeding.
You were going 101? What do you want to do? Be a NASCAR driver? Huh?
No, sir.
Well, come on. Where do you work at?
Nowhere right now.
Why not?
We bought a truck recently. I've been out of work since
Since what?
summer.
Since summer?
Yeah, I got hit by a truck and broke my foot, collarbone, and
Oh, jeez. Well, I hope it wasn't your fault. You got a lawsuit going. Listen, I don't want to talk about your injuries. You try to figure out a way you're going to get back to work.
yes, ma'am.
Is Mr. Pelland, I was calling him?
Last time I was here, he tried to change the case over to a driving or allowing a licensed driver.
Yeah, I don't know what happened. Mr. Pellin, your name, let me talk to him.
James Pelland on behalf of the city of
I
Rockland.
don't know what happened, but last time I wrote down defendant was here but left.
Okay. Yeah,
Reschedule case. Stip form was something. I can't even read my own writing. That should tell you how bad it is. I don't see a stip form in the file. Oh, wait a minute. There is one.
yeah, I believe we changed it to allowing on the drive.
Yeah, would you do another one today and have him sign it? Let's get this young man out of here. I feel bad if we made him wait. I made him wait whatever last time. You paid your speeding ticket, right?
Yes, Your Honor. That
Why would you have done that? What was he charged with on the speeding? You have the file.
Judge, his speeding was 26 to 30 over is what he paid on.
My
It was
God.
235.
Have they yanked your license yet?
Yeah, they just sent me the.
Yeah, of course. It can't be. Why did you do that? Go work this out with him. Pull the other file and give it to Mr. Pellin. And young man, you're going to learn to slow down though. Got it?
Yes, Your Honor. Thank you.
Crazy. 1 in 70. What's the hurry? Mr. Lyon, come on, please. Joseph Michael Lyon, 26B 149926. B. He probably paid something too. Your name? Name?
Joseph Lyon.
Where you been?
Yeah, first I'd like to apologize, Your Honor. So my driver's license had my old address on it. So all the court documents were sent to.
Did you bother to tell anybody?
I told.
The officer gave you the ticket on January 7th, right?
Yes, sir.
Did you really think we didn't get around to scheduling the case? You didn't?
I've never been in trouble criminally, or the only tickets I've ever had has been for, I think, going 10 something over in parking. So and the ticket was sent to my current address. I gave them my current address. So like I received the ticket at my address, but I never received any court dates. They were all sent.
Where do you live?
I live in Newport, up in North Dixie.
Do you see anything about Newport?
It was changed in the system.
Hang on. What's the zip there again? In Newport.
Say again?
The zip code.
Oh, 48166.
Tell me where you live. You said Newport, but what's the address?
Yeah, 7974 North Dixie Highway.
You have the right to a lawyer. You're charged with leaving the scene of a property damage accident. You went into default on left of center. You have the right to a lawyer. I'd be happy to give you one at public expense if you want one. Would you like one?
I would, yeah.
Okay. We'll set you up with a lawyer. You'll talk to the lawyer. Either way, you'll come back in front of me, okay?
Yes, sir.
Be a little bit more responsible, will you please?
I'll have that ID renewed. I want to make sure.
Do you hear what I'm saying? You owed us a phone call. Okay?
Yes,
Come on. Jeez.
yes, sir.
Good luck.
Thank you.
We'll set you up with a lawyer. James Edward Carter Jr., 26R 514-511, A and B, and C.
Those are the cases decided thereunder. To the extent a conflict does exist, given the waivers, the court will consent to hear the matters. The court does call the case of the people of the state of Michigan versus Romeo.
First Assistant Public Defender on behalf of Mr. Smith, who I believe is appearing by Zoom. Mr. Smith, please state your name for the record.
I'm Morris Smith.
Okay.
Thank you, Judge. I believe we are in receipt of a competency finding. And I believe that should be in the court's possession.
Yes.
I think we're prepared to skip to those findings.
And that's the February 4th.
Yes, Judge.
February 4th. So the defense stipulates, people stipulate to those findings.
Yes,
All right. The court, in reviewing those findings, would find that the defendant is no longer incompetent to stand trial and therefore competent to stand trial. That he can understand the nature and objects of the proceedings against him and can rationally assist in his defense. Therefore, the defendant is deemed competent. I have signed the order to that effect. And what would you like this next set for?
Thank you, Judge. You would not mind please setting it for PCC? We greatly appreciate it.
I'll set a probable cause conference for March 5th. 2026, 9 a.m.
Thank you, Judge.
Bond will continue. Thank you. Call case People versus Avion Johnson.
Andrew, do you want me to put it on the application?
Sherilyn Foster Tucker on behalf of Avion Johnson, standing in for attorney of record at Drukas.
And I had this is in custody. Where is he?
He is in custody. He is on leave.
Oh, there he is. Mr. Johnson, can you state your name, please? If you just talk, Mr. Johnson, I think you're unmuted, sir. Mr. Johnson, can you hear me? I don't think he can hear me. Is that okay?
Yes, sir.
I don't know, because I'm not hearing any background noise there at all. I cannot hear him. All right, can you try to send him a message that will pass this matter and call him back up that you're emailing? So he'll see that on the screen. Maybe, hold on. Oh, okay, gotcha. I can't even tell if he can hear me or if it's just, we have no sound. Mr. Johnson, if you can hear me, just wave your hand. Yeah, he can't hear me. All right, I'll pass. You're going to email them. All right, I'm going to pass.
Okay.
Court does call the case People versus Jawan Crawford.
Yes, good morning, Judge Alan Cooper for Jawan Crawford.
Good morning, Your Honor. Assistant Attorney General Clarissa Williams on behalf of the people.
Your Honor, I've discussed the matter with my client. He's agreeable to waiving the preliminary exam.
Your name, sir?
Jawan Crawford.
And you're going to waive your preliminary examination?
Yes, sir.
All right. You understand that that's a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them?
Yes, sir.
You understand that you'll not have that hearing. You'll proceed to circuit court for further resolution.
Yes, sir.
People also waive their right.
Yes, Your Honor.
Preliminary examination having been waived, defendants found over to circuit court on the 2 counts.
Your Honor, may I
Counsel,
address
you
the issue of
acknowledge-
bond again?
Well, let me do the arraignment and then I'll do that. Do you acknowledge receipt of the information, waive its reading?
Yes, Your Honor.
And at this time, your client stands mute?
Yes, Your Honor.
Defendant every way form of reading, standing mute to both counts. Court will enter a not guilty plea. I will set circuit court pretrial for
March 2nd at 1:30 with Judge Mood.
March 2nd, 2026, 1:30 before Judge Hamoud. Yes, that's the bond.
Yes, Judge. I made this request last week as well. My client, unfortunately, he had a difficult time with his employment over the past 2 or 3 years. He was injured. However, he has been seeking employment. He actually does have a job offer letter substantiating that he's got a job waiting for him. Now that letter is from a company called Real Truck, indicating that his start date was actually supposed to be the day before yesterday, but he thinks that if he follows up with him, he might still be able to get this job underway, which is obviously significant because the whole crux of this case is to get some kind of payment schedule. If he's not working, then he can't work out a payment schedule with the prosecutor. So I understand that there's been some non-payment over the past year or so. That's because he has been unemployed, but now he actually does have employment. And he's trying to properly put this matter behind him. So I think the fact that he actually does have a written job offer is good cause to reduce the bond. I would like a personal bond because that's all he can afford. The family is in court. There's no risk of flight. He's got 5 brothers and sisters. All of them have tried to talk and try to compile some, even the 25%. None of the family members can come up with this. So it's going to be up to Mr. Crawford to actually try to get payments to work something out ultimately when he deals with this felony child support case. So because he's got this job waiting for him, it's solid, it's confirmed, it's in writing. I would just ask that the bond be reduced to a personal bond and let's deal with the matter at circuit court.
Are you saying the 25,000 that was listed on the complaint was only non-payment for a year?
Yes.
Is that what you're indicating, counsel?
Your Honor, I didn't do all the math on it. I think his support was set at about $1,200 or $1,500 a month.
Yes.
And I'm not sure if it was for 1 year. I think it was over a period of 2 years, or maybe a year and a half or so.
I mean, the difficulty is that the statute, I mean, I hear your argument, but the statute very clearly dictates 25%. I'm not sure that a job offer, and this court wouldn't find that a job offer in and of itself is going to constitute good cause, but
otherwise than what you're doing, then you're looking at punishing him for basically what he's actually charged with.
I'm not punishing him. He didn't pay for his child, so don't put it on me.
Well, in effect,
if you don't pay for your children, this is what happens. This is the punishment for doing that. So don't put it on the court or anybody else. The legislature made the statute. It says 25%. I'm not punishing him for anything. If he doesn't meet the standard of good cause, he doesn't meet the standard of good cause, counsel. Do I have a response from the people?
Yes, Your Honor. I would agree with you. We would ask that you deny modification of the bond specifically to a PR bond. Again, as stated last week and as stated today, lack of payments, promise to pay, to me, in my opinion, is not good cause to modify the bond. While the defendant was out and free and not under course, not incarcerated, he had the opportunity to pay. The amount that accrued is now at over $32,000, and that was over a few years. So we have no guarantee that just releasing him and him seeking a possible employment opportunity will guarantee payment. And for those reasons, Your Honor, we would ask that you deny modifying the bond today. Thank you.
This is nothing different than I heard the last time that he was here. And quite frankly, the court in it would be of rights to up his bond because the amount is now higher than it was in the complaint. But I'm not going to do that. I'm going to leave it where it is at this point. But I'm not going to find that there's any good cause. Once again, motion for bond reduction is denied. Bond will continue. Thank you.
Thank you.
Court calls case People versus Stephen Javon.
Michael Gaddy, Assistant Public Defender for Mr. Gavon, Your Honor.
Lucky here. Ron.
You want to state your name? You want to state your name?
Mr. Javon, state your name. Oh, I see.
He's refusing at this time.
He's refusing. Okay, but that is Mr. Javon according to your records. Officer.
Your Honor, I think this is a competency review. I didn't receive any kind of.
I didn't receive a report either.
I did try and see Mr. Gavon and he refused me yesterday.
He refused it. Okay.
Judge.
Yes.
Is this the case where we adjourned so we could do a casual and he's had me finding a number of months ago, but has refused to come out to court? Just trying to remember the case.
I believe that Yes, it is. He's not, the last opinion is he's not competent to stand trial, but he is at least present via here. I think the last time he wasn't coming up, we did not have any communication with him, but I would consider him to be present at these proceedings now. Since he's appearing via tablet, although he doesn't want to say anything. So I'm going to, is there any other additional evidence regarding finding of competence?
There is, I don't have anything further, Judge.
Anything
As I
from the
said,
people?
No, Judge.
Court would find that the defendant at this time is incompetent to stand trial. I will sign an order to that effect.
I'll type that up and send it to the court.
Well, I have an order that was signed.
Thank you.
I'll set a competency review hearing for, give me 90.
May 14th.
May 14th, 2026, 9 a.m. Bound continue. Thank you. Court calls case People versus Derek Hunt.
Good morning, Your Honor. Assistant Attorney General Clarissa Williams on behalf of the people.
Assistant Public Defender Chelsea Regiles with and on behalf of Derek
Well,
Hunt.
get out of the way. Come on, Mr. Hunt. Mr. Bird is just lingering in the eye. Just
Please state your name.
Derek Hunt. Oh,
your name, sir.
Derek Hunt.
All right.
Your Honor, we're asking to adjourn this to continue a plea discussion.
Probable cause conference in this matter will be adjourned to March 12th, 2026, 9 a.m. Bound continue.
Thank you, Your Honor.
Thank you.
Thank you.
Court calls case People versus Nikita Griffin.
Good morning again, Your Honor. Assistant Attorney General Clarissa Williams on behalf of the people.
Assistant Public Defender Chelsea Regiles with and on behalf of Nikita Griffin. Mr. Griffin, please state your name.
Peter Griffin.
Thank you.
I'm here. Your Honor, I believe Mr. Griffin would like to waive his right to a preliminary exam after a plea discussion. The offer he's interested in would require him to waive this.
Sir, is that correct that you want to waive your right to a preliminary exam?
Yes, it is.
You understand that that's a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed it.
I do.
You understand you'll not have that hearing and that you'll proceed to circuit court for further resolution. You understand that? All right. People also waive the right.
Yes, Your Honor.
Preliminary examination having been waived, defendants bound over on 2 counts. Mr. Deals.
We acknowledge receipt of the information, waive its formal reading and stand mute.
Defendant having waived formal reading, standing mute. Court will enter a not guilty plea. Pretrial in this matter will be set for
March 19th at 1:30 with Judge Slay.
March 19, 2026, 1:30 before Judge Slay. Mr. Giles, anything regarding bond you want to accuse me of keeping him in?
I don't believe so. I think bond is set.
I know that was unfair. Is there anything regarding bond, Mr. Giles?
No, thank you.
All right, thank you. Bond will continue. Thank you, sir.
Thank you.
Is that it for Attorney General or she got more? That's it? All right. Thank you, Madam Attorney General. Court calls the case of the People versus Ashley Albert. That's why it went sideways. Constantino was over there, but see, I didn't even see her.
Yeah, a little,
It was Gaddy. Gaddy was blocking.
yeah. It happens a lot, Judge. Christina Costantino appearing on behalf of Ashley Elber. I believe she is appearing via Zoom. Ms. Elber, can you please state your name for the?
Ashley Elber.
Oh, there she is. Okay. All right, you're seeking an adjournment.
Yes, Your Honor. I was just appointed to Ms. Elber's case late last night, so I do not have discovery. I also need to have an opportunity to meet with her and discuss her matter. So I would be asking for an adjournment of the probable cause conference.
Probable cause conference objection will be adjourned March 19, 2026, 9 a.m. Bond continues.
Thank you very much, Your Honor.
Thank you.
Thank you.
Thank you, ma'am. Court does call the case of People versus Braisha Anderson.
Assistant Public Defender Jay Dollinger on behalf of Ms. Anderson on cases ending in 5640 and 5026, Your Honor. We're also aware of the bond violation this morning.
Yes,
Hi.
sir. Brandon Bird on behalf of Bryce Anderson on the case ending in 5330.
And Ms. Anderson, can you please state your name for the record?
Bryce Anderson.
And Your Honor, as to the PCCs on this matter, we would be asking for an adjournment. I have spoken with the prosecutor. He's looking for a mitigation on this, which I'm happy to draw up, but that will take a few weeks.
Here, Your Honor.
All right, so you want me to adjourn that and the bond violation, or?
Your Honor, after speaking with our client, it's my understanding that she is willing to plead guilty to the violation this morning. We do have an explanation.
Adjourn to probable cause conferences then will the 5th be enough time for you to get done what you need to get done, or do you need the 12th?
I would need the 12th, Your Honor.
Adjourn these to March 12th, 2026, 9
I'm gonna come meet with you so we can.
As to bond, I guess, the court having accepted her plea guilty to the violation.
Respectfully, Your Honor, our client wasn't able to get in the house in which she was living. So her tether died. Am I correct?
Yeah. Our understanding is that she has a roommate, Your Honor. Her roommate locked her out of the house. Her phone was in the house. Her tether died. She wasn't able to get back into the house and charge it. She does apologize to the court for the violation. She really had no way to do it. As to the missed test, Your Honor, again, she didn't have a phone at the time. She couldn't call.
Did she not have the charger? Or
she did not have the charger that was in the home.
did she go to community corrections?
She did not, Your Honor. She had no way to get there, and she otherwise would have called them. However, her phone was in the house. Is that correct as well? Okay.
Well, what actions did she take to try to get it charged?
I just tried to get back into the house and I just tried to try to find it. Try to have her give me the charger or throw it through the window or something, and she wouldn't let me.
Where was the house was located? Where?
It was the one on Packer. It was the apartments on Packer.
It's a pretty tumultuous relationship with the roommate, Your Honor.
Okay, I get that part of it, but I guess what I don't understand, if she's on Packard, why she didn't just walk over to community corrections?
I honestly didn't even know I could have just come over and just said like, hey, I didn't have the charger. I really just didn't know that. I rather was trying to get it.
Well, where is the charger now?
Still in the house.
So if I were to let you out, where would you? Well, first of all, you didn't appear was one of the things. Why didn't she appear for the hearing?
Your Honor,
the last hearing, the jail did say that my client wouldn't come out the cell. Now, after speaking with Ms. Anderson, Your Honor, she's been very polite to me. She has been very polite, and I believe we're able to work together now to get some of those issues handled. That's one of the reasons why we're trying to put in this mitigation report for mental health issues. My client does suffer from mental health issues, Your Honor, but she understands that she has to show up to court. She understands where she doesn't want to be at this time.
Okay, when she's locked out, where was she then? I mean, when she was locked out, where was she?
I was on Packer.
what did you do when you were locked out of the house? You were still at the house?
No, I ended up going over to my godparents in-laws. Ended up going over there and staying over there for a minute, and then going back to my apartment every day trying to get into the apartment. And that's where I got arrested as.
Okay, so when you went to your godparents, did you ask them to give you a ride to community? I mean, I guess I'm not understanding.
I never thought to come up to community corrections because I have to call a number, right? You can't just come up. You have to call the number, and the number says your number or color, and then you come up. But without my phone, without the charger, I just didn't do it. I never thought to just pop up and come up. I didn't think to do that. It just wasn't in my mind to do that. I get what you're saying, but I just really honestly didn't think to do.
Johnson.
No objection to a release for treatment, but I do have concerns for this defendant's own well-being. On the new case, the 26 case, in that report, the defendant indicates she attempted to harm and kill herself using drugs. So I'm concerned that when you don't have testing and there's this prior history of an attempt to use those drugs to commit self-harm, we might not see this defendant again if released on her own without any sort of supervision. So I think release to treatment would be good and appropriate, but otherwise I would ask.
Would you be okay with a release to treatment? Is that something you want us to?
Yeah.
Okay. Your Honor, I have, after speaking with my client, it's my understanding that she herself would be okay with the release to treatment. So I'm happy to submit an order to the court.
All right. So what I will do is
I can submit it on your case too.
I'm going to continue her bond at the amount it's at. They'll sign once it's presented to me in order to release to treatment.
I'll include you on the email.
I'll also adjourn the sentencing on the violation to the March 12th date. So I'm not going to sentence her on that. I'm just going to leave everything where it is. We'll get the order. If she can get released to treatment, that'd be great. I think that might be the best thing.
Okay. Thank you very much, Your Honor.
Thank you.
Okay. I'll be in touch. Okay.
All right, thank you.
Thank you, Mayor.
Sweetheart.
Mr. Johnson. Yeah. Recalls case people versus Avion Johnson.
Sherilyn Foster Tucker on behalf of Avion Johnson, standing in for attorney of record Ed Drukas.
Mr. Johnson, can you state your name?
Avion Johnson.
Okay, now we have you. Okay. You don't have any problem with Miss Foster Tucker appearing for your counsel of record?
No, Your Honor.
All right, thank you, sir. All right.
And Your Honor, Mr. Drukas is seeking an adjournment. I believe they're close to a resolution.
Got it. All right. Probable cause conference will be adjourned then to March 5th, 2026, 9 a.m. Bond will continue. All right.
Thank you, Your Honor.
All right. Thank you, Mr. Johnson.
Thank you.
Court calls the case of the people versus Harold Couch.
Morning, Your Honor. Jacob Kennedy on behalf of the people.
And good morning, Your Honor. Joseph Hall appearing for and on behalf of Mr. Couch, who now stands to my right. Mr. Couch, if you could state your name for the record.
Harold C. Couch Jr. He's waiving.
That's correct statement, Your Honor.
Sir, you're waiving your right to a preliminary examination?
Yes, I am.
You understand that that's a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed it?
Yes, I do.
You understand you'll not have that hearing. You'll proceed to circuit court for further resolution.
Yes, I do.
People also waive their right?
Yeah.
Preliminary examination having been waived, defendants bound over to circuit court on a single count. Mr. Hall.
Your Honor, we'd waive formal reading, stand mute at this time.
Defendant having waived formal reading, standing mute. Court will enter not guilty plea. Pretrial will be set for
April 15th at 1:30 with Judge Conlon.
April 15, 2026, 1:30, Judge Conlon. Bond will continue.
Thank you.
Thank you, Your
Thank
Honor.
you. Court calls case of the people versus Edna Grima.
People.
Please, Honorable Court, on behalf of Edna Gurma. Ms. Gurma, please state your full name for the record.
Excuse me, Edna Joy Gurma.
Thank you. What are we doing?
Respectfully, Your Honor, I just got appointed to this matter. We're gonna ask for.
And you're not ready? No, go ahead. I'm sorry. Okay.
We're gonna ask for adjournment on this matter.
All right.
I'm gonna have to turn in my green sheet.
You don't have it?
I don't.
What have you been doing? Besides, never mind.
Not doing me like that. Not doing me like that.
Probable cause conference. I'll just adjourn it out in 2 weeks, let you get caught up and do that. Okay, Ms. Gurman?
Gotcha.
March 5th, 2026, 9 a.m.
And permission to address bond, Your Honor.
Yes.
Respectfully, my client did have she did about 30. She doesn't want to make any excuses why, but she wants to move forward and knows that she can move forward. She's 61 years old. been through a lot in her life, but she is trying to make things right. She has a Stop the Gun Violence outreach program that she's preparing for in June that's sponsored by the sponsored by the city of Ypsilanti, in which she's the administrator for and makes a lot of things happen for that. She understands that she needs to work at it. She does have meds that she's not receiving right now. She does have a therapist that she goes to when she's out there for some mental conditions that she suffers from. And she did put in a referral for Down Farms and mental health, in which she told me that
For Don Farms and mental health too.
No,
Go ahead.
okay. The Washington mental people gave me an intake.
For Don Farms.
Yes, sir, for the outpatients on Gulfside.
All right.
So respectfully, Your Honor, we're just asking that this wise and honorable court give Ms. Gurma a chance. No, give her a second.
Wise nor honorable.
Wise.
But go ahead.
Give Ms. Gurma a second opportunity, and she will prove to this court that she can abide all bond conditions.
Yes, sir.
Any response from the people?
Judge, I believe that you changed your bonds because of contingency use.
Yeah.
And what she's doing in the jail is admirable, and I think that she can get started with the process now.
What I'm going to do, just listen to it. I'm going to deny your request. However, I will sign, if I have not, a release to treatment. Okay. What's wrong, Ms. Gerber?
This would be our 5th event,
I know.
and it's in honor of my nephew who was killed on Thanksgiving in 2021, and all gun violence families, survivors, and the community.
But hold it. Maybe you're not hearing what I'm saying.
Shut up. I'm gonna shut up.
No, you can talk to me. I don't have a problem with that. The release to treatment I'm not saying that it has to be inpatient treatment. I'm saying she can be, but she's gonna have to be released to treatment. It sounds to me like you started that process. So if we can get that all worked out, I'm not gonna have a problem with that, because that's really what you need. And although you're trying your best, you can't do that on your own. That's just the reality. And you know that as well as I. Okay?
Okay.
So, counsel, if you get me a release of treatment order, I'll sign it.
All right, thank you. Thank you, Your Honor.
All right. And for her, it can be inpatient or outpatient treatment, but I want something structured around her before I'm even going to consider releasing her for whatever reason.
All right, sounds good, Your Honor. Thank you.
Thank you. Court does call the case, People versus Mario Taylor.
And good morning, Your Honor. Good morning to your fine staff. May it please this most honorable court, Edward Martell, P85051, on behalf of Mario Taylor, who joins us via Zoom. Mr. Taylor, please state your name for the record.
Mario Taylor. Good morning, Mr. Simpson.
Thank you. All right, what are we doing?
Judge, discovery is complete. We're asking for a preliminary examination date. Please and thank you.
Date except for is what? Pardon, sorry. No other witnesses available March 3rd.
Yes, Your Honor.
Preliminary examination in person will be set March 3rd, 2026, 9 a.m. before
Judge Freshout.
Judge Freshout.
Your Honor, I don't know if it's possible. Would it be okay to have it set before Judge Perry? The only reason I'm asking is because co-defendants have exams set for the same date before Judge Perry. It's the same witnesses.
Co-defendants have?
Yes.
All right.
If co-defendants are set, there's no reason for me to set it before two different judges. I'll set this before Judge Perry.
Thank you.
Bond will continue.
Thank you, Judge.
Thank you.
Have a great
Case
day.
People versus Ernest Gardner.
Sherilyn Foster Tucker on behalf of Ernest Gardner.
I did, yeah. Your name, sir?
Ernest Gardner.
All right, what are we doing?
Your Honor, we're requesting a preliminary exam. Discovery is complete to my knowledge.
People have witnesses available the third preliminary examination in person, March 3rd, 2026, 9 a.m. This will be before Judge Freshour.
Thank you.
Council should be aware, although it won't matter for me, there was a communication sent from the defendant to the court, which the court has a copy of. I don't know if you have copies.
I don't.
All right. Thank you.
Thank you.
Continue. Court calls case People versus Jacob Grammatical.
People, Your Honor.
And good morning, Your Honor. Joseph Hall, appearing for on behalf of Mr. Grammatico, who currently stands to my right. Mr. Grammatico, if you could state your name for the record.
Jacob Grammatico.
Thank you.
And Your Honor, at this time, if people are unable to proceed as to count one, would ask the court to remand down to district court on count two.
No objection.
Count one, you're moving to dismiss.
That's correct statement, Judge.
All right, dismiss. I'll continue as not guilty plea. As to count two, I'll set a pretrial in that matter,
March 18th at 9 a.m.
March 18th, 2026, 9 a.m. That is before me. Do you believe? Well, now, this wouldn't go to the 18th. This is a DV.
I apologize. March 2nd. At 1 p.m.
March 2nd, 2026, 9 a.m. before me. Thank you.
Oh, at 9 a.m.? Okay,
Yes.
I can make
All right, I'm sorry, 1 p.m.
1 p.m., even better.
Thank you.
So that I could make you happy, Mr. Hall.
I knew you were trying, Judge.
Yes, I was. All right, thank you.
Thank you very much, Your Honor.
Yes, yes, Your Honor. Court calls the cases of the People versus Kawandake, yeah. Thomas.
And Sherilyn Foster Tucker on behalf of Ms. Thomas in the cases ending in 1211 and 5653.
And Michael Gaddy, Assistant Public Defender in the cases at 1945 and 5565, Judge.
All right. Okay. Your name, ma'am?
Hello, I am Kiwana Place, Cynthia Rose Thomas. Good morning, Your Honor.
All right, what are we doing?
Your Honor, Ms. Thomas understands that she has an absolute right to a preliminary examination. She wishes to waive that right and seek a full resolution in circuit court to her matters. I do have an executed advice of rights. I have advised her of her right to exam.
And same for my
On
matter.
your fifties. These are all 1 pound. Ma'am, you understand you have a right to a preliminary examination?
Yes, Your Honor.
You understand that by waiving that hearing, that, I should say, you understand that that's a proceeding where the people would have to show by the standard of probable cause that the offenses alleged were committed and that you committed them. You understand that? If you don't, tell me you don't, and that's okay.
Yes, I understand.
All right. You understand that you will not have that hearing and that you'll proceed to circuit court for further resolution of all 4 matters. You understand that?
All 4 matters or all together?
Well, you have 4 cases, I think, for me.
And each has, I think, one count on it. So
Okay.
you'd be going to circuit court on all of these 4 charges in these 4 cases. You understand that? For them to be resolved there.
Your Honor, I think the confusion may lie that she has 14 matters total pending in all the courts, and she's waiving these matters up, and we're going to seek a global of all of those.
Got it. But are the other 10 then already up?
They're misdemeanors.
Oh, they're misdemeanors. I got it. Okay. So they're trying to resolve all your cases.
Yeah.
Got that? You understand that part?
Yes,
These cases that I have before me are all felonies.
yes,
So they're trying to get all of these up to circuit court.
yeah,
And then I think the plan, whether it works or not, but the plan is to resolve these 4 cases as well as your other cases, all with one big resolution.
right,
Okay, you understand that?
yes,
Okay. And so you understand that a preliminary examination or that hearing, you're not going to have that. You're going to go up to circuit court
yes,
so they can try to resolve it.
yes.
Okay. You have any other questions regarding that?
So is there, if I bring these cases up, or is there a chance that it's going to be separated then?
What do you mean?
Like these 4 from all the other cases?
Well, they're already separated anyway, because I think your other 10 cases, they told me are misdemeanors, and so
Oh,
they're in district court. And they're trying to get all 4 of these up to the circuit court.
Yeah.
judge, And they're just going to try to resolve everything.
We're gonna
Tried
get,
to resolve everything, but they're all in different courts.
okay,
You okay?
yeah.
You understand all of that?
Do I go home today then?
Well, I don't know that that'd be the case, but.
Yeah, I understand.
You understand. All right. People also waive their right.
Yes.
Preliminary examination having been waived, defendants bound over on a single count in all 4 cases.
Your Honor, in terms of the public defender cases, we waive reading, stand mute on the arraignment of the information, acknowledge receipt.
We'd also waive formal reading, acknowledge receipt of the information, and stand mute.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea. Pre-trial in these matters will be set for
March 2nd at 1:30 with Judge McNally.
March 2nd, 2026, 1:30 before Judge Hamoud. Bond will continue. All right.
Thank you.
Thank you. Court calls the case, People versus Michael McClure. Your name?
Michael McClure.
Who is it? Joe?
Yeah.
It's like a squirrel. Just took off. Well, no, Miss Constantino ran out to.
She's a little more swift.
Yeah, she's little. She'll get lost in the hall. Okay, there he is.
Lost in the hall.
Well, no, we were not concerned about that. Everybody was concerned that Miss Constantino wouldn't make it back.
Good morning, Your Honor. Joseph Alpering Ford on behalf of Mr. McClure, who stands to my right.
Your name?
Michael McClure.
All right. You're requesting an adjournment?
That's correct, Your Honor, to review discovery. I was recently retained in this matter. I have received 6 videos. I do believe there may be call for service and dispatch that I have yet to receive.
March 12th, 2026, 9 a.m. Bond continue.
Thank you very much, Your Honor.
Thank you.
Yep.
Court calls case People versus Corey Blair.
Alexander, on behalf of people here.
Public Defender Chelsea Virgils, with and on behalf of Corey Blair. Please state your name.
Corey Blair. Thank you.
Your Honor, we're asking to set a preliminary exam in this case. I believe all discovery is complete.
Yes. Would the people have their witnesses available on the 3rd? Preliminary examination in this matter will be set for March 3rd, 2026, 9 a.m. before Judge
Judge Perry.
Perry. Yes, as
Your Honor, in my attention, this defendant has made 61 calls to the victim through her listed number from his PIN since he's been arraigned. So at this point, I'm going to be asking that his phone privileges be revoked.
any response?
Your Honor, Ms. Senda did make me aware of that allegation yesterday. I haven't heard these phone calls. I would ask for a hearing on that.
All right. Well, I'll tell you what, you can. I'll set the preliminary examination as well as a hearing on the bond violation before Judge Perry on that date. That would seem to me to make most sense. And then I will order that the defendant's phone privileges are hereby ordered revoked pending that hearing. Yes. Until we can also get it straight, counsel, I'm not only revoking his phone privileges, I'm also revoking any texting privileges that he may have at this time also. Thank you.
Thank you.
Court calls case People versus James Kearney, Senior.
Morning, Your Honor. Raymond Cook with People.
Well, are there two?
Yes.
Are they both on today?
Yes.
This says senior.
Okay. Sherilyn Foster Tucker, standing in for attorney of record Ed Drukas on behalf of.
You were born the last day of 76. Just need to take your hands out of your pockets. Oh. All right, then that's
Okay.
the one I call.
On behalf of James Kearney Senior.
All right.
Say your name.
Oh, James Kearney, senior. Thank you. All right, what are we doing?
Mr. Drukas is seeking an adjournment. I believe there is a resolution. He just needs some time to finalize it.
Probable cause conference and will be adjourned to March 12th. 2026, 9 a.m. bond continue. All right, thank you. Court calls case People versus Kenneth Dorsey.
People. Michael Gaddy, Assistant Public Defender. Approaching.
Your name?
My name, Kenneth Dorsey.
Thank you. What are we doing?
Your Honor, I've gone over his right to an exam with Mr. Dorsey. He understands he has the right to preliminary exam. He wishes to waive that exam and seek resolution in the circuit court. I believe upon waiver, the people in circuit court would offer to dismiss one count in exchange for the a plea, and the other would not object to it.
So you're waiving your right to a preliminary examination?
Yes, sir.
You understand that that's a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them.
Yes,
And you understand you'll not have that hearing, you'll proceed to circuit court for further resolution.
yes,
People also waive their right.
Yes.
Preliminary examination having been waived, defendants bound over circuit court on both counts. Mr. Gaddy.
Your Honor, we'd waive reading, stand mute on the arraignment on the information, and we acknowledge receipt.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea. Pretrial will be set for
March 2nd at 1:30 with Judge Hamid.
March 2nd, 2026, 1:30 before Judge Hamid. Bond will continue. Thank you. Court does call the case of the People versus James Kearney Jr.
Raymond Cook with People.
James Kearney Jr.
Right here.
Anna Mackey, requesting permission to practice under Michigan Court Rule 8.120 under Senior Assistant Public Defender Joy Gaines.
She's here in spirit. Permission to practice is granted, Ms. Smith. All right. Your name, sir?
James Kearney Jr.
All right. What are we doing on this? Requesting an adjournment?
Yes, Your Honor, we're requesting an adjournment and we'd like
Ms.
to.
Mackey was doing a fine job.
Oh,
No, she really was. And
she was,
she was.
but we're all,
She was. I don't know why she went and sat down.
I don't know, Your Honor.
Why'd she do that?
I don't know. She's maybe.
You should have
maybe
made her,
he's
you should
getting-
make her get back up here. She just left the podium. Didn't say goodbye, Judge, didn't say anything. She just left.
Joy Gaines, Senior Assistant Public Defender representing James Kearney Jr. And Your Honor, his father is out in the,
Who?
he is present by Zoom.
Oh, yeah, he's right here.
Yes,
He's been here for a while.
yes, he has.
And he stated his name.
Yes. So we are asking for an adjournment so that we can discuss with him the offer. We are also wanting to address bond. At this time, there's a no contact order with his father and that he cannot return home. I was hoping to see if his father was able to stay for a minute in case you have questions for him.
Okay.
My client is 18 years old and his father.
Go ahead. I'm sorry.
And his father did indicate that he wishes to have his son return home. It's the family home. He's only 18 and he has no objection to contact. And I believe that my client would have no objection to not talking about the cases and no objection to avoiding any kind of assaultive or aggressive behavior. And it is my understanding that the issue was between his father and his uncle, not he and his father, based on what the father is saying. But my client will abide by whatever rules the court has for him to return home.
Response from the people.
Your Honor, I did discuss this with Mr. Rugas, the attorney on the father's case, and he indicated to me, I believe, that he was looking for something similar, but didn't know what was going to happen on this case. I still don't think it's a good idea, given that the underlying incident here was the two of them were arguing with each other. Police came in to try and diffuse the situation. That's when both of them started confronting the police officers, which led to the charges here.
So it was a dad and his son in an altercation. Police get there.
Try and break it up, both dad and son.
And then the family turns on the police, the people coming in between them.
Essentially, yes, that's the short version. So I don't think it's a good idea to have them together, but ultimately, if they think that they can handle it peaceably between them.
If they're a father and son, they're gonna, well, let me put it this way, they're gonna handle it.
Emphasis on the peaceably between.
Well, right, but sometimes. You got a son? No?
No.
No?
No.
Most of the time you try to have it peacefully. Sometimes you just gotta say stuff as a dad.
I do have a father, though, if that's any consolation.
Okay. I'm done talking. No, he was. Not gonna even ask. All right. Here's what I'm gonna do. First of all, I'm gonna adjourn this case out to March 12, 2026 at 9. And then what I'm gonna do is I'm gonna continue to bond in its all other terms except the no contact. I will allow contact. I will allow. So there was a no contact and a no go to on the son.
That is correct.
So I will delete those provisions. I'll permit consented, or I'll permit contact. I'm just gonna leave it at that. And these gentlemen have to learn to behave themselves. Got it? Dad is standing right there. We'll do the same thing. I won't call it back up, but I'll
change that on his case also. Is that all right with you, Dan?
Sir.
All right, we're good. Okay,
All right,
thank you. I'm just gonna allow contact. They'll figure it out. Court calls case People versus Shannon French.
Assistant Public Defender, Shanazi Kyriakou, Your Honor, on behalf of Mr. Shannon French, who's approaching. Mr. French, state your name for the record.
Keep going. Thank you.
Because we're asking for an adjournment in this matter, I did speak with First Assistant Childers. He wants to check and see if he will be able to extend an offer in this case.
Probable cause conference, March 5th, 2026, 9 a.m. Bond continued.
Thank you, Your Honor.
Thank you. Court calls case People versus Michael Smith.
Chavalowski for the people.
And Your Honor, Christina Costantino, on behalf of Mr. Smith, I am just preemptively placing that appearance on the record.
And yes, Your Honor, Brandon Bird, on behalf of Mr. Smith, momentarily.
I don't even know what that means.
We put in.
Yeah, there's an order, I think. No, I saw it and I signed it.
I didn't know if I had to put the motion on the record, Your Honor, or.
No, you're gone.
All right, sounds.
You're out.
Thank you, thank you.
All right.
Appreciate it.
All right, bye. Is that it for you for today? Oh, darn. All right.
Well, Mr. Smith, can you state your name for the record?
Michael Smith.
All right.
And Judge, given that I've just been appointed, I would obviously be asking for an adjournment to get discovery and discuss.
And I set your last case on the 12th or 19th?
I think you did the 19th.
All right. Probable cause conference, March 19th, 2026, 9 a.m. Bond continued.
Thank you very much.
All right,
Judge.
thank you.
Have a good rest of your day.
You do the same. Court calls the case People versus Michael Furnace.
Judge, Portia, please speak first. Center on behalf of Mr. Fernand. State your name for the record, sir.
Michael Christopher Furnace.
Thank you, Judge. I have spoken to Mr. Cook on this file. I am requesting a brief adjournment on this case if we try to find a resolution.
Probable cause conference, March 5th, 2026, 9 a.m. Bond continued.
Judge, there was one issue with bond, if you don't mind,
Sure.
Judge. I did speak to Mr. Cook, and I think he has no objection to Mr. Fernandez being released to treatment. Should the court think that's a good idea?
Released to treatment?
Yes, sir.
Okay, I'm not gonna have a problem, but if you get an order, I'll sign off.
Thank you, Your Honor.
Thank you, sir. Court calls case People versus Terry Williams.
Raymond Coach of the people.
Oh, boy.
Morning, Your Honor. Please,
I was trying to call it as fast as I could to get you out. All right.
Brandon Bird, on behalf of Terry Williams. Mr. Williams, can you please state your full name for the record?
Yes, Terry Williams. Thank you.
Just asking for that brief adjournment, Your Honor.
Conference will be set March 12th, 2026, 9 a.m. Bond will continue.
Thank you, Your Honor.
Thank you.
You and Your Honor, before have a great day.
You do the same. Court calls the case People versus Thamar.
2009, which is quite a bit of time since he's had any law involvement. And most of those, all of those have been misdemeanors or minor misdemeanors before the 2023 charge. Obviously, he'd like to continue to be out in the community, and a jail sentence I don't think is going to serve him well. I don't think he has a chance of reoffending with Ms. Castela, as he's not going to oppose a no contact order. There's been a no contact order in the pendency of this whole case. I think both of them have realized they need to stay away from each other. And he has great support, family support. His mother has been here the whole case. He lives with her. He has a great, stable home environment. And he just liked to put this behind him no matter what.
Mr. Ward, what do you want to tell me? It's all about Your Honor, and she knows I was on probation across the street, and she done this on purpose. And I don't know why, and she does this to everybody. She goes out lied about the pictures, everything else. Can't believe what happened.
Court's going to put you into my community control program for a period of 3 years. I'm going to place you on standard or basic probation. I'm going to impose the rules of probation that are standard on you. That includes no alcohol, and you are not to be any bars or restaurants that serve alcohol. I'm going to order you to serve 60 days in the county jail, credit you to 2 days that you have already done. I'm going to let you schedule that through probation so you can make it work with your schedule. We do need to get that set sometime within the next 90 days. I'm not going to impose a fine. I am going to impose the costs. I want you to enter into and successfully complete outpatient drug and alcohol. If you leave the state without permission or you don't follow the rules, then I can sentence you to up to the maximum penalty in the case, which is 180 days in jail. Anything else we need to do? Anything I forgot?
No, Your Honor.
All right, you do have the right to appeal this to the 12th District Court of Appeals in Middletown. If you don't have the funds to hire a lawyer to obtain a transcript or to pay the cost, they will all be provided to you at no charge. Good luck to you, Mr. Ward.
Thank you.
Your Honor, if I may, if he would be eligible for the litter program at all.
Yes, that'd be fine. Go ahead and do the litter entry if you don't mind, beside him. Okay, what that means, Mr. Ward, is if you go out on the litter crew, you get an extra day of jail time credit for every day you go out with the crew. So if your 60 days are up, you can probably cut that down to maybe mid-40s. Okay?
Thank you.
All right, we're in recess. Sometime within the next 90 days, so probation will do a supplemental commitment when it's time for him to go.
Yes, yeah. He's in dealing with help. Okay.
All right.
Jones.
You're gonna read it to the people.
Apparently, yes.
To not be carried, I can really, on behalf of Mr. Thamar Johnson, Mr. Johnson, state your name for the record.
Lamar Johnson.
Thamar. We're asking for an adjournment, Your Honor.
Probable cause conference, March 5th, 2026, 9 a.m. Bond continued.
Okay, Your Honor, I apologize. Okay, there is a piece of evidence that we were still waiting for. I had spoken with my client previously. We said we were going to set for exam. Once I spoke with the prosecution today or yesterday, they informed me that they're still waiting on that. I wanted to adjourn. It's some DNA evidence. Yes, my client would like to, he wants to move forward with the preliminary examination even without it.
And for what Your Honor, I did reach out to the OIC and they want to provide with a date when we're going to get that back. They said as soon, and I don't know how to interpret that. They should.
I mean, I'll set it, but you understand, sir, that if it comes in, it's not going to be the basis for an adjournment because we know that it's missing.
I mean, Your Honor, I've been waiting,
I hear you. I wish DNA could be done faster. It just, there's some logistical reasons and others that it can't be done that quickly, but,
You're okay.
no, I'm just saying, I just got out of the joint on the 23rd, on the 3rd of September.
On they said
my DNA and all.
You got out
before I got out.
Hang on. You got out when, the 3rd of September?
Yes. Okay. And before I get out, they swabbed me and they took my blood for DNA and put it on record. I don't know why it's taking so long.
But it's not his DNA, it's DNA from
the scene.
From the scene, right. So when they swabbed you, yeah, that has been done. It's the DNA from this scene that's the problem.
That's what they're trying to. No. So what do you want to do? Do you want to wait or do you want to set?
I mean, I'll do whatever you want me to
He
do,
wants
but
to-
pardon?
He wants to set it, Judge.
Okay, I can do it two ways. So I can have it set. I could set it later out so you can see if it's gonna come in here, because I don't know what soon means.
Neither. Left a message with Paul. I haven't heard anything.
So I'm gonna have one, so you've got the time.
I'll check. I'll check.
So what do you want me to do? You want me just to set it and hope for the best, or? I mean, I can.
I've been waiting.
One thing, right, but one thing I can do is I can go to the 5th, like we were planning. If it's not, then just remind me and I'll just kick it out to my next date, which would be the 24th, which would be right around that same time, just to see if this stuff gets in, because it may exonerate you. I guess that's part of the problem, so.
Oh, the 5th? I think we're fine with that, Judge.
We're doing it that way?
Yes, yes.
Okay, so I'll set it the 5th for probable cause conference. Just remind me that, or what I just said, that if it's not back then and you want it set, I'll just kick it to my date and we'll go from there. How's that sound? Fair enough? Yeah. Okay, thanks. Bond.
Fair enough.
Court calls case People versus Malik Asidi.
Yes, Your Honor.
The public defender should not be carried. I can rule, Your Honor, on behalf of Malik Al-Saidi.
Yes. Sir, state your name.
Malik Saeed.
Malik Al-Saidi. Your Honor, we are asking for an adjournment. I believe the court should be in receipt of a green sheet.
I am.
We've kind of escalated this matter and we're waiting for negotiations to complete.
Escalated?
Yeah.
Would you cause some problems? I mean, if you're saying you're escalating stuff.
It ain't
really?
my case, Judge.
It ain't.
Michael Gaines, assistant public defender. No, Your Honor, we're just in the process of plea discussions, and I'd ask the court to adjourn it to allow us to continue.
Sir, I'm going to adjourn your case to March 19th, 2026, 9 a.m.
Thank you,
All
Your
right,
Honor.
sir. All right.
Your Honor.
Thank you. Bond will continue.
I'm sorry, you said March 19th?
Yes, sir.
Thank you, Your Honor.
Thank you. Court calls the case of the People versus Thomas. Is it Sharon or Sharon?
For the judge, Portia Feature, assistant public defender on behalf of our client who approaches. When you arrive, please state your name for the record, sir.
Thomas Sharon.
Thank you, Judge. I've had some brief communication with the people on this case. I think we're still looking for a potential offer and resolution. We're asking for a brief adjournment, please.
March 5th, 2026, 9 a.m. Bond continue.
Thank you, Judge.
Thank you.
March 5th. All right, we can go with deputy.
Well, I gotta stay there till March 5th.
Yep. March 5th.
What day is it now?
Today's the 28th.
Court calls the case People versus Renee Andrews.
People.
And Maggie, on behalf of Ms. Andrews. Approaching to my right. Is that your name? Renee.
Thank you.
Your Honor, we'd like to set this matter for exam and all discovery is complete.
People, are the witnesses available the 3rd?
Yeah.
Preliminary examination in person will be set March 3rd, 2026, 9 a.m. before Judge Freshour. Bond will continue.
Thank you, Your Honor.
Here. Court calls the case of the people versus Darnell Taylor.
Assistant Public Defender Jay Ballinger on behalf of Mr. Taylor, who approaches, Your Honor.
Your name, sir?
Darnell Taylor.
Thank you.
Your Honor, we are just asking to set this matter for preliminary examination. To my knowledge, all discovery is complete.
Maybe approach.
You may. Bad things for.
Number. It's the same charge. It's just they got their pack code wrong.
All right.
I need to correct that. Okay?
And the people, you said you'd have your witnesses available the third.
We'll go, Mr.
All right. Preliminary examination, March 3rd, 2026, 9 a.m. before Judge Perry. Bond will continue.
Thank you.
Thank you, Your Honor.
Thank you, Judge.
Court calls case of the people versus Jennifer Baker.
For Judge Torsia Fleecer, Assistant Public Defender, on behalf of Ms. Jennifer Baker, who is approaching. Ms. Baker, please state your name for the record.
Jennifer Lynn Baker. Good morning, Your Honor.
Good morning.
Thank you, Judge. Ms. Baker has asked me to look into some financial records on this matter. If we could have a 3-week adjournment or more, that would give me some time to have my investigator look into it.
So she's got to look into some financial records, get them to you.
Yes.
And then if they're relevant, get them to the prosecutor.
Correct.
That could take all year. Probable cause conference, I'll adjourn it to March 19th.
Thank you,
Hopefully
Judge.
that'll give you enough time to do what you need to do. 9 a.m. bond will continue.
Thank you, Judge.
Thank you.
All right, this is my card.
Court does call the case, people versus Melinda Baker.
Excuse me, Michael Gaddy, Assistant Public Defender on behalf of Ms. Baker, who is appearing via Zoom, Your Honor.
Yes, she is. Ms. Baker, can you state your name for me, please?
Melinda Baker.
Thank you.
Your Honor, we're requesting an adjournment. There's another matter that needs to be, we're trying to get some information on, as well as discuss the matter with the people.
In Oakland.
Yes, Judge.
Probable cause conference, March 19th, 2026, 9 a.m. Bond continue.
Thank you, Your Honor.
Thank you. Thank you, Ms. Baker.
Thank you.
Case of the people versus Jeffrey Ball.
Maggie, on behalf of Mr. Paul, who should be on Zoom. Oh, who's actually approaching to my right.
Your name, sir?
My name is Jeffrey Ball.
Thank you.
We're asking to adjourn this matter, Your Honor.
Probable cause conference will be adjourned March 12th, 2026, 9 a.m. Bond continue.
Thank you.
Thank you. Court does call the case of the people versus Cedric Blair.
Assistant Public Defender, on behalf of Mr. Blair, who is approaching.
Mr. Blair, state your name for the record.
Cedric Blair.
Judge, we're asking for an adjournment in this matter.
You have his violation from the second.
I do, Your Honor.
Let's address that.
Okay. Your Honor, I do understand that the violation report indicates a number of missed tests, as well as a number of positive tests on the SoberLink device. And I see also that there was a missed test on 129, and the test before that on the 22nd was positive. I've had an opportunity to speak with my client about this. Mr. Blair has, he was very upfront with me. He wants to be very upfront with the court. He has admitted that he has been struggling. He states that he has been trying to do this on his own, but it's clearly something that he cannot. I've spoken with him about all of the options available. We're going to ask, I do have on the printer, but I can submit.
Is he admitting to the violation?
He will be admitted to the violation.
Okay, go ahead. I'm sorry.
I do have a release to treatment order drafted up if the court would be willing to sign that. I've explained to him the benefits of a lot of the treatment facilities that Washtenaw County offers, or at least we're able to get him to. And he says that he wants to take a serious attempt at this. He's looking to reunite with his 18-year-old daughter, and he wants to be the best version of himself when he does that.
If I may, I'd also like to add that I have 2 different interviews coming up. And if it's somehow that I am able to walk out of here without going to treatment, treatment is definitely an option. But could we maybe, I would suggest an alcohol tethered versus the SoberLink, because I have actually forgotten this in places before, which is why I missed a couple tests and whatnot. But that would be.
Well, the missed tests don't bother me as much as your positive test. And the SoberLink doesn't, or the Scram doesn't necessarily help with that. We got to find a way to get your addiction under control, and to really have you fulfill what your counsel's indicated is probably the most admirable thing you want to do, and that is be the best version of yourself for your daughter. All right. If that requires me to not let you walk out of here, that's what I'm going to do. Okay, because I think you want to do that. And I just looking at the best way to do it. You had a number of, you're really slipping. And I'm not, in saying that, I'm not saying that you weren't trying. I think that you were. You just have come to the realization you can't do it yourself. I'd also like to add, if I may, another thing of that for my stress is trying to find employment. And I have, like I said, I have an interview today at 1:00, and I have an interview at Biggs tomorrow. That was part of my stress and my basis for not coming to drop. I called the number, but if I didn't have the money, I didn't come. Because, I have to collect bottles just to get the bus fare down here for them to tell me, well, if you don't have the money, then you can't drop anyway. So it's like, it was a catch-22. So I was like, I've even put my applications in like McDonald's so I can at least have the money to pay for my drug screens. And there was no one to borrow from or nothing. Like, I have no one. Yeah. All right. What I'm going to do is I'll adjourn this probable cause over to March 5th, 2026 at 9. At this point, based upon the violations and that he's admitted to those violations, I'm going to cancel the bench warrant that's out there. But I'm going to revoke his bond and remand the defendant to custody. I will sign the order regarding release.
Thank you. I'll have that submitted to the court right away.
I apologize, Your Honor. What's March 5th?
March 5th.
Yeah.
Court calls the case People versus Xavier Braxton.
Hannah Mackey on behalf of Mr. Braxton, who should be on Zoom. Mr. Braxton, can you state your name?
Xavier Braxton.
I'm setting this matter for exam and all discovery is complete as far as we are aware.
He deployed
Yeah, he's the one that was serving in the Michigan.
Right. Are you currently deployed? If I said it, am I going to be able to get him back? I mean,
Oh, right now he's here.
you're here now.
He's going
yes,
to go
sir.
to Romania soon.
Pardon?
He's going to Romania, I believe, soon. Getting deployed to
He's
Romania.
going to be deployed to Romania.
Was it Romania?
Yes, ma'am. 2027.
Oh, 20.
Oh, in 2027. Okay. All right. And you want this set for exam? So,
Yes, exam, please.
preliminary examination in person will be set March 3rd, 2026 at 9 a.m. That is before Judge Fresh Hour.
I'll be in touch, Mr. Braxton, okay?
Yes, ma'am.
Continue. All right. Thank you, sir. Court calls the case People versus LaShawn Charles.
And Assistant Public Defender Jay Bellinger on behalf of Ms. Charles, who appears via Zoom. Ms. Charles, can you please state your name for the record?
LaShawn Charles.
Thank you.
Your Honor, I am desperately trying to work out some sort of offer for Ms. Charles. I'm going to request another adjournment.
Desperately?
Desperately. I'm doing everything but kissing the ring, so I'm doing my best.
I'm glad you said ring. All right.
That's fair.
Probable cause conference will be adjourned March 12, 2026, 9 a.m. Bond will continue.
Thank you.
All right.
Thank you, Ms. Charles.
Thank you so much.
Court calls the case of the People versus Zion Cheatham.
Assistant Public Defender Jay Bellinger on behalf of Mr. Cheatham, who should be an appearance via Zoom, Your Honor.
I think he is. Cheatham, can you state your name, please?
Zion.
All right, I have before me a plea form. Indicates he would be pleading guilty to the charge of attempted possession of a loaded firearm in a motor vehicle. The 1-year offense. Upon a successful plea to that charge, count 1 would be dismissed. He's agreeing to forfeit the firearm. And their sentencing judge waiver has been signed. That's the court's full understanding of the agreement.
That is our understanding of the offer as well. Mr. Cheatham, that's your understanding of the offer?
Yes, sir.
That's the people's understanding.
Yes.
Mr. Cheatham, can you raise your right hand, please? Other right hand. There you go. All right. You solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, Honor. Yes, Your Honor.
All right. State your name again for the record.
Zion Cheatham.
All right, sir, it is this court's understanding that you're going to be pleading guilty to the charge of attempted possession of a loaded firearm in a motor vehicle. That is a misdemeanor punishable by up to 1 year incarceration, a $1,250 fine plus court costs, and mandatory forfeiture of the weapon or device. You understand that?
Yes, sir.
All right. You also understand, sir, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Washington in the 14B District Court. You understand that, sir?
Yes, sir.
Still wish to plead guilty?
Yes, sir.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you will not have a trial of any kind.
Yes, sir.
All right. You signed an advice of rights form or had one signed on your behalf?
Yes, sir.
You have any questions regarding any of those rights?
No, sir.
Looking at paragraph 5, those are your rights which are part of a trial. You understand that you're giving up those rights as well as all the rights on that form.
Yes, sir.
You understand you're giving up your right to appeal of right.
Yes, sir.
Are you on probation or parole?
No, sir.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No, sir.
Anybody threaten you or coerce you?
No, sir.
You're doing this voluntarily?
Yes, sir.
Of your own free will?
Yes, sir.
And because you believe that you're indeed guilty of this offense?
Yes, sir.
December 22nd, 2025, at the location of Ford Boulevard and Holmes Road in Ypsilanti Township, Washtenaw County, State of Michigan, were you in a motor vehicle?
Yes, sir.
And in that motor vehicle, did you possess a pistol?
Yes, sir.
Was it loaded?
Yes, sir.
And where was it located in the vehicle?
Under the seat, yes, Your Honor.
Did you have any authority whatsoever to carry a weapon in that fashion, sir?
No, sir.
Sir, if I accept your plea, I do have to advise you that if you commit misconduct between the time of my acceptance of your plea and the time of sentencing, the court would no longer be bound by any sentence evaluation or recommendation, and you would not be entitled to withdraw your plea. You understand that?
Yes, sir.
Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
No, none, Your Honor.
And have I complied with the court ruling? Would it be proper to accept this defendant's plea?
Yes. Yes, Your Honor.
Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. A pre-sentence investigation and report is ordered at 14B probation. Sentencing in this matter will be March 26, 2026, 10 a.m. before Judge Washington.
Thank you very much.
Bond will continue. All right. Thank you, sir.
Thank you. Hey, Your Honor, I have one question.
Sure.
I had got a letter in the mail about a payment that I have paid. I have the email for it too, so I just wanted to make sure that everything on that end was taken care of. It said it had to be paid by February 4th, but they already paid it the day after my court day.
That was on the case before me?
Yes, sir.
Okay, so you paid the money to my court?
Yes, sir.
I mean, to us,
yes,
right?
Yes, sir.
Okay, it should all be taken care of. What I would do, that probably went out at whatever point. Okay. I would just wait a couple of days, make sure you have your receipt and just check on it again.
Okay, no problem. Thank you.
All right, if there becomes a problem, get in touch with your attorneys at the PD and they'll try to come into my office. I won't let them in, but all right.
All right, Your Honor. Thank you.
All right. Thank you.
Thank you.
Court calls the case, People versus Douglas Crockett.
Under Chelsea Ridgefield with and on behalf of Douglas Crockett, who appears via Zoom. Mr. Crockett, please state your name.
Douglas Crockett.
Thank you, sir.
We are asking to adjourn for a plea discussion and we haven't received media discovery yet.
You have not received it?
No, Your Honor.
How soon is that going to happen?
Well, we're going to go over today.
Probable cause conference, March 12th.
Oh, excuse me.
2026.
Excuse me. Can I ask
Yes,
a question,
sir.
please, Your Honor? As far as my bond conditions, I wanted to see if I could ask in regards to where it states that I'm not able to return to the address 2129 Medford Road in Ann Arbor, Michigan. I wanted to see if that particular portion of it could potentially be lifted. That is my home address where I live with my twin brother, and I'm currently staying with my mother in West Bloomfield, and I work in Plymouth. And with doing my weekly drug test, having to come out to Washtenaw County and having to drive back, it's been very difficult due to the distance. And I was trying to see if possible, if that portion could be lifted.
Did you ask your attorney about that?
I didn't know I could ask.
Your Honor,
You know anything about that?
I didn't, Your Honor.
Probably not.
I would have
He
to
shocked us all.
consider it. I think he makes some valid points, Your Honor.
He does?
I would ask the court to consider his request.
Any response from the people?
Your Honor, we haven't had a chance to talk to the victim. It appears to be.
That's going to be the problem. Problem is, sir, you should have gone through your attorney with that. I don't mind listening to you. I understand what you're saying, but usually what will happen is you let your attorney know, which you've now done out loud. They then will let the prosecutor know, which you've also done out loud. The prosecutor will then talk to the alleged victim in the case, get their feelings on it, and then hopefully we can get it resolved. If they can do that and stipulate to something before the 12th, then I don't have a problem, I don't think, signing off on it. But in terms of your request right now, I'm going to deny it. I'm not going to change anything until all of the proper people have been contacted.
I understand.
Understood?
Yes.
All right. So I adjourn this out to the 12th, 9 a.m. Bond will continue. Thank you. Court does call the case, People versus Juwan Daniels.
And Mac, on behalf of Mr. Daniels, we should be on Zoom.
Yes, sir, state your name.
Juwan Daniels.
Thank you.
Your Honor, we'd like to set this matter for a preliminary exam and all discovery is complete as far as we're aware.
People have their witnesses available the 3rd.
Yes.
Preliminary examination in this matter will be set March 3rd, 2026, 9 a.m. before Judge Perry.
Thank you.
Bond will continue. Thank you.
Daniel,
Thank you,
be in touch. Sorry, Your Honor.
Court calls case People versus Robert Dolan or Dolan.
Assistant Public Defender Chelsea Vergils with an on behalf of Robert Dolan. Please state your name.
Robert Dolan. Thank you.
Your Honor, we are asking to adjourn for some investigation into additional discovery.
March 19, 2026, 9 a.m. Bond will continue. Thank you, sir. Court calls case People versus Amber Dunson.
Judge. Court shall feast the first assistant public defender on behalf of Ms. Dunson, who is approaching the podium. Please state your name once you arrive.
Amber Dunson.
Thank you, Judge. I have spoken to my client on this matter. I believe this is her first PCC, I believe. We'll be requesting a brief adjournment for further negotiations.
House conference will be adjourned March 12, 2026, 9 a.m. Bond continue. Right. Court calls case People versus Grant Jacia.
People. Yeah, Michael Gaddy, Assistant Public Defender from, I think he calls it Duche. Your Honor, I have not had contact with Mr. Duche. I know he has profound medical issues. It's my understanding he missed court yesterday as well.
Yes, he did. Bench warrant will issue for defendant's failure to appear. Bond.
To the rest of my day,
Okay.
About this, I took this, I understand asking for help is a strength. I understand all of this.
Okay.
And I believe in and I'm not a person who needs to get in trouble repeatedly. I don't have a court record of being in trouble over and over.
What's the best way for you to get sober and stay sober?
I've been going to groups and stuff. That's what I've been staying sober, Your Honor. That's what I've been staying in. These swab tests just wasn't correct. Because when I left here after court, I went over there at the jail and I even cleaned there and it says, you guys said it was dirty.
Okay. Well, the problem with this is, let's talk about the drug test for a moment. Nothing's perfect. No system's perfect. Occasionally, the tests are going to be wrong, but it's such a small percentage. You have to just discount that and deal with the probably 97% that are accurate. And if you're that unlucky, it's just a really interesting circumstance because you are a person who has been violated on probation 3 times already. And you have to just face the facts. So we've tried everything we can do, and your probation is now revoked. You are placed, you're ordered to serve 180 days in the Warren County Jail. You get credit for 154, and we're done with you. If you choose to get into
AANA or some support group. You can do it on your own. If you choose to not use, you can do that. If you don't choose that, I'm afraid you're going to die from this. It's that simple. All right, that's all.
Your Honor, what type of termination would you like?
I'd say neutral because she has been in jail.
A set amount of $10,000 cash surety. That warrant will issue immediately.
Thank you.
Thank you. False case of the People versus Jacob Pike. Do you know what cases you have? You're always looking at me like it's some great mystery. There's private counsel?
Good morning, Your
So it's
Honor.
not your case. Then sit down. Jeez, oh, Pete. Go ahead, counsel.
Philip Kavanaugh, P number 59404, appearing for the defendant. I have filed an appearance in this matter, but not substitution of counsel. So I believe
that may be why.
Mr. Gotti is the public defender on this. But I was called in once again. I filed an appearance, but not a substitution. I would ask for an adjournment so that I could have a conversation with the prosecutor.
All right, I don't mind that. And if you guys can just make sure to accomplish a substitution so we get everything changed. So probable cause conference will be adjourned March 12th, 2026, 9 a.m. or as your invite indicates.
Sir, when you do the substitution, this is Mike Getty. Have Delphia Simpson as the public defender, and we can put the bar number. Thank you.
All right, thank you.
May I ask who the prosecutor is, who I should contact?
Sure. I don't know who.
So, sir, you can reach out. This is Raymond Cook. I'll likely be handling the case. You can reach me at email.
Cookar, Washington.org.
Raymond Cook. Okay, thank you, Your Honor.
Thank you. I don't know how I knew that. I don't think I've ever sent you an email. I just knew how to do that. I'm smart. Court does call the case. People versus, and bond will continue on the Pike matter. Court calls the case. People versus Brittany Fisher.
Madam Mackey, on behalf of Mrs. Fisher, who should be on Zoom.
Yes. Ms. Fisher, can you state your name, please?
Yes, Brittany Fisher.
Thank you.
Yeah, and I would like to set this matter for exam, and all discovery is complete as far as we're aware.
Becky's an exam machine.
Gotta get the ball moving.
And would the people have their witnesses available on the 3rd?
Yes.
Preliminary examination in person, March 3rd, 2026, 9 a.m. That's before Judge Freshour.
Thank you. Ms. Fisher will be in touch, okay?
Okay, thank you.
Bond continued. Thank you, ma'am. Court does call the case of the People versus Tyshawn White.
Charlotte Stephan on behalf of Mr. White. Your Honor, he's appearing via Zoom.
Yes, he is. Mr. White, can you state your name, please?
Tyshawn White.
All right. What are we? Thank you. What are we doing?
We're setting it for exam, Your Honor.
All right. Discovery is complete.
Yes, it is.
All right. Would the people have their witnesses available the 3rd? Preliminary examination in person, March 3rd, 2026, 9 a.m. before Judge Perry. Bond will continue.
Thank you, Your Honor.
Thank you. Thank you, Mr. White. All right. That's 11, finished basically right on time. Court's going to stand in brief recess. We'll come back, start the 11 o'clock block shortly. Court's in recess.
All rise.
Where's Mr. Carter?
Checked in with me.
What's your name? Come on up here. I just called your case. You can tell me your name. All right, good morning. You have a unregistered vehicle. That's a misdemeanor. You have a no proof of insurance, a disobeyed traffic signal. Those are civil infractions. You have the right to a lawyer. If you want one, I'll give you one. Do you want a lawyer?
No, thank you.
I'll go ahead and arraign you then, and I'll send you to the prosecutor.
Okay.
On February 2 of 26, it is alleged that you did operate a motor vehicle that was unregistered on I-75 near Huron River Drive in the city of Rockwood. That is a misdemeanor. Punishment of $100 fines, 90 days jail, costs, or all of those. Do you understand that?
Yes, sir.
You have two other charges here: disobey a traffic signal and no proof of insurance. Those are civil infractions. The disobey traffic signal would be a 3-point violation. You understand that?
Yes, sir.
And did you sign, read, and understand the advice of rights?
Yes.
If you plead guilty at any time, you'll be giving up all those rights, and there will not be a hearing or a trial. Do you understand that?
Yes, sir.
All right. You still wish to waive your right to a lawyer?
Yes, sir.
I'm entering a not guilty plea. I'm giving you a personal bond. We're going to take this to the $500 personal bond. You don't have to post any money. You cannot leave the state without the consent of the court or violate any law. You must appear in court as directed. We're going to take that over to the Rockwood prosecutor. You'll meet with him. You can go down the, I don't know what the only is in John conference room 2, I guess. Go meet with him, and then you'll come back in front of me. Any questions?
No, sir.
All right, see what you can resolve with him. Good luck. Andrew Joseph Ellis Webb, 26B82402A, B and C. Your name?
Andrew Webb.
All right, you're charged with vicious dog, and then you have 2 civil infractions. Dog at large, no license. Do you have the right to a lawyer? If you want one, I'll give you one. Do you want a lawyer?
Yes, sir.
All right. I'm going to go ahead and set you up with a lawyer. You go down the hall, and we will set you up actually in the hallway, and we'll set you up with a lawyer. And either way, you're coming in front. Give that to the defense attorney too. Okay.
Thank you.
Lucinski, Christine Francis Lucinski. File 26F245459. Good morning, Ms. Aycock.
Good morning, Your Honor. Leslie Aycock on behalf of Ms. Luzinski, who's present to my right. And I think I said that wrong. I apologize. We're here for an arraignment pre-trial, Your Honor. For arraignment purposes, we would stand mute, waive formal reading.
Ma'am, your name?
Christine Luzinski.
All right, so I'll enter a not guilty plea. Does she have any prior offenses?
She does not, Your Honor. She's 41 years old, no prior criminal history whatsoever. In fact, no points on her license, nothing. Lifelong Gibraltar resident, continues to reside there with husband, 2 minor children, and her parents also reside with her in that home. So we would ask for a non-cash bond.
$1,000 personal bond. Ma'am, you cannot leave the state without the consent of the court. You cannot violate any law or ordinance. You must appear in court as directed. No alcohol, no marijuana, or illegal controlled substances. You cannot purchase, possess, or consume any one of those. Again, you can't leave the state, can't violate a law. I'm signing your discovery order. I'll give you a pretrial date. What do you have there, Heather?
We could do Tuesday, March 3rd at 1:30.
Is that good with you?
Yes, that would be fine. Would that be Zoom, Your Honor?
If, as long as your client's in the same location, I don't have a problem with that.
Okay. And this may be a bit premature because I know we'll be coming back to court before that, but I'd just at least like to mention to the court, my client's husband works out of state currently. She was planning on taking her youngest child, the 12-year-old, on a school break to see him in Tulsa, Oklahoma from March 27 to April 1.
Can we state between March 27
in April, we'll say the 2nd, in case she stays another day. Okay? So I'll
Thank
give
you.
you
We
that
appreciate
permission
that.
now. And we'll see you guys back here. If you want to be on Zoom together, that's fine with me. Have a good day. And
Thank
they'll
you, Honor.
send you
You
the
too.
discovery order. Thanks. William
Thank you.
Edward Miller the fourth. 26R514439A. All right. Your name?
William Miller, Your Honor.
Nice and loud for me, okay?
William Miller, Your Honor.
All right, so you paid the ticket. You guys talked further, that speeding ticket, which is gonna devastate you.
We did take Kim ran the speeding ticket down there, but she said they weren't in the office, so I'm not sure if they looked.
It's fine, you can keep it, because they're just gonna
Okay.
go ahead, in light of that, it looks like he's gonna just dismiss the no ops charge, so that's what I'm gonna do here. That case is dismissed, you're all set, you gotta slow down, son.
Yes, sir.
Good luck to you, thank you, have a good day. And as soon as you can work, get a job, good luck. Mr. Crawford, do you have something for me?
I do. I have, Mr. Ganal.
Okay, people against, Nevin Todd Janot, 26R514412. Good morning, Mr. Crawford.
Morning, Mayor Michael Crawford, representing Mr. Ganal.
Mr. Janot, your name?
Not at all.
All right, so we have a super drunk. And for purposes of arraignment, how does he wish to proceed?
Steve, I have to stay and wait for reading of the charge, Your Honor.
All right, so I'm entering a not guilty plea for arraignment purposes. Now they're going to go ahead and dismiss. They're going to dismiss the super drunk. He's going to plead to impaired driving, and it was a blood draw, so there's going to be $225 in recovery costs. True?
True.
Sir, if you plead guilty to operating while impaired, the 6-month misdemeanor will be dismissed. The possible penalties on this are up to 300 fines, 93 days jail, 360 hours community service, court costs, or all of those. 4 points would be added to your traffic record. Your license would be suspended or revoked in accordance with your record, and your vehicle could be or might have to be immobilized depending upon your record. Do you understand all of that?
Yes, Your Honor.
Did you sign, read, and understand an advice of rights form here today?
Yes, Your Honor.
If you plead guilty, you'll be giving up all those rights on the advice of rights, and we're not going to have a trial of any kind. You understand that?
Yes.
All right. You have any questions before I ask you how you plead?
No, sir.
To the charge operating while impaired, how do you plead?
Guilty.
Were you operating a motor vehicle on December 27 of 25 at 10:39 PM on I-75 near Woodruff in Rockwood?
Yes, sir.
Did you drink alcohol prior to that?
Yes.
What did you drink and how much did you drink?
It was about, 7 to 8 years.
I'm sorry?
7 to 8 years.
And was your ability to operate the motor vehicle impaired due to the consumption of the alcohol?
I believe it was.
In what way? Why were you pulled over by the police?
Speeding.
You think you were speeding at least in part because of your alcohol consumption?
Yes, sir.
Did you take a breathalyzer or you took a blood draw, right?
Blood draw.
Counsel, were the results 0.194 and you so stipulate that was accurate for purposes of the plea?
Still stipulated.
Are you on probation or parole, Mr. Janone?
Currently, no, sir.
Anybody force you to plead guilty?
No, sir.
Please accept it. He's got a prior in 18. That's not good. And he had a pretty high blood draw here. You got to use your head, son.
Yes, sir.
I'm debating if I need to order a sober link. To be honest with you, I'm accepting the plea of impaired driving, dismissing the super drunk.
Well, Your Honor, I don't think it would be appropriate for a sober than my client in this case. He was under a little bit of stress. He made a bad decision. He's a sole caretaker for his grandmother who was very, very sick and was upset and just drinking. It's not a regular thing for him.
Well, he had this, and it was not an operating while intoxicated or impaired. It was the minor zero tolerance back in 18. I'll give you $1,000 personal bond. No alcohol, no marijuana, no illegal drugs. You're not to purchase, possess, or consume any one of those. My court officer is going to give you an AA form. You have to go in person at least twice a week. Every time you go, you have to have the form signed. Every time you come to court, you have to bring the form with you. I'm ordering a screening and assessment. You'll be screened and assessed today. You'll come back for sentencing. We're going to do that one, Heather.
That will be March 19th at 8:30.
Young man, where did you grow up? Did you grow up in Rockwood?
I did.
All right, so we have a court to school program. I want you to keep in mind, is that the 26th or 7th?
The 26th.
Would you run in and ask Amy if she's heard from the principal yet as to when it starts?
She has not. I asked her this morning and she has not heard back yet.
I handle that then. I'd love to have you in my court to school program. I'm not going to lie to you. It's going to be more embarrassing than doing it here where you have 20 or 40 people or whatever, 9 people sitting in the court in the audience. You'd be its shoemate, okay, in Gibraltar. You don't have to do it. If you choose to do it toward any jail, and I'm not going to send you to jail on this unless you violate, toward any jail, court work, or community service, I'll give you a day of credit. Is this your mother?
That is mother.
You can see you upset her. Can't be doing this stupid kind of junk. It kills the parents more than the. At any rate, you don't have to do it. I'd appreciate it if you do it. I'm not going to treat you worse. I promise you that. Whether you tell me I want to do it or I don't want to do it, but you're going to get a day's credit. So it's up to you.
Yeah. I could do that.
Okay, so here's what I'm going to do. I'm going to schedule it for March the 26th at 8 a.m. Mr. Crawford, you're good that day?
Yeah, I'll get into it.
And listen, I want you to get his number.
Yep.
And I want you to call the court.
Good.
And Mr. Janot, I don't want you to lose sight of this. We don't know what time. Right now, I'm going to tentatively say be there at 8. Okay?
Yes, sir.
But you stay in touch with your lawyer. He will know in the next week. Okay?
Yes, sir.
And I'm giving you the personal bond. Did you get your AA sheet? You're going to start that?
Yes.
All right. Do you work?
I do.
Where?
I'm a manager at Chess for Chess Pizza.
All right. You graduated, right?
Yeah.
Okay. All right. Okay, good. Good luck to you. Go down the hall, get your notice, and then go over to probation where you'll fill out a questionnaire. That's the screening and you'll be interviewed. That's the assessment. Okay?
Thank you, Your Honor.
Have a good day. Thank you. Good luck. You'll be all right, Mom.
Yeah.
Priority Waste LLC, 26B149904.
Good morning, Your Honor. Alex Dillon appearing on behalf of Priority Waste,
Mr.
P52.
Dillon, I don't know what we do without the fines and costs from this organization. We can at least keep the lights on. You know what I'm saying?
Yes,
I don't mean to be well, I don't want to bring up a touchy subject. At any rate, I'm surprised they keep doing this. Why do they keep doing this?
Your Honor, we were issued 17 tickets on Tuesday. It's frost law season and law enforcement just. I report to the people that are responsible for hauling trash and tell them how to comply with the law, and I'm doing my best, but.
I get it. All right, so you're authorizing on this plea, there's gonna be a plea to overweight with agreed upon fines and costs of $1,200, right?
That's correct.
To that charge on behalf of the company of overweight, responsible or not responsible?
Responsible.
I'll accept the plea, $1,200. I'll give them till April 1. Is that good enough?
Yeah, thank you.
Have a good day, Mr.
I'm telling you,
Dillon.
if I got my CDL, I would not get pulled over. I would not be overweight, and I would be efficient.
I know, I believe it.
We might all have to.
Have a good day. Take care.
Take care. Thank you, Judge.
James Carter. James Edward Carter Jr., 26R 514-511, A, B, and C. All right, Mr. Carter. Your name, sir.
James Ricardo Jr.
So you negotiated with the prosecutor. He's going to dismiss the unregistered vehicle misdemeanor. You're going to plead to disobey traffic signal and no insurance, right?
Yes, right.
You don't have insurance now, do you?
No, I do not.
You don't have a valid license because you're revoked. How long you been revoked? Since 2003?
2018.
You talk to a lawyer, you just keep driving. You get another drunk driving. My gosh. You've had 4, right?
Yes.
You can't drive, sir. I don't know what to tell you. I'm surprised they didn't. I don't know why they didn't write you for drive while revoked. Peace. Did he tell you why? Did they give you a warning?
Yeah, warning.
Jeez. The charge, no proof of insurance, responsible or not responsible?
Responsible.
To the charge, disobey traffic signal, responsible or not responsible?
Responsible.
I'll accept those pleas on the no proof of insurance 185, on the disobey traffic signal 145, the unregistered vehicles dismissed. Mr. Carter, please do not come in front of me on a revoked charge. This is ridiculous. You got to stop driving.
That's right.
You're pretty clear you haven't paid attention to that. I'm surprised. You'd be in deep trouble with me.
Is there any way I can set up a payment plan with fines?
Where do you work?
I'm self-employed and personal slow. And
Doing what?
Doing kitchen and bathroom remodels.
And how do you get to those?
By a cab, so I guess somebody that works for me that drives.
All right, okay. That's a canned answer I hear every day. If you pay the disobeyed traffic signal charge, how long do you need on that?
A month. The week 30.
Paid by March the 19th. On the other case, 185, paid by April the 19th. If you don't have the money, you call the court, we'll go on Zoom, I'll give you an extension. Please don't come in front of me on a revoke. I will not be this kind. My hands are tied with that plea agreement. Good luck. Thank you. Are they ready out of Trenton on these?
They're both ready. Trenton's also ready.
I want to get the interpreter to. Come on up here, Cole Blakely Sammons. Are you here? 25B149145. All right. Your name.
Cole Blakely Sammons.
Raise your right hand. You solemnly swear affirm under penalties of perjury that the testimony you'll give in these proceedings should be the whole true self you got.
I'm sorry, what was that? I was waiting for Mrs.
Listen, look, come here. Just raise your right hand. You solemnly swear or affirm under penalties of perjury the testimony you will give in these proceedings will be the whole true self you got.
Yes, Your Honor.
Okay. You understand what you just took an oath to tell the truth, right?
Yes, Your Honor.
Okay. Right. You can put your hand down. Since you were in court on September 17 of 25, have you been arrested for any other charges?
No, Your Honor.
Have you had any contact with the police for any reason?
No, Your Honor.
Do you have any other cases pending?
Currently, on a few programs right now, and I'm paying fines.
Slow down. Slow down. Have you picked up another offense at September 17?
1.5, right?
Yeah.
No.
Well, are you on probation to other courts?
I'm on probation for this courthouse.
For what? Are you in front of me or Judge Hess?
Heston,
For what?
trespassing.
When did that take place? Were you on probation on that when you pled on this?
I don't remember, Your Honor.
Heather, can you check that, please?
His offense date on the other one was August 2nd. And this one was August 4th.
Okay. I'm going to go ahead and dismiss your case on motion of the prosecutor. Take everything out. Yeah, I'll be glad to do that for you. You weren't on probation on this case when you picked up that one. You've got the thing that was holding this up is proof of employment, which you provided, and you paid your $225 today, correct?
Yes, Your Honor.
Case dismissed. Good luck to you.
Thank you.
Stay out of trouble now.
Yes.
All right, I got it. All right, let's do Henry Franklin Joseph Lent, 260-725-297.
A little rubber ground. Mark, I'm going on. Be careful with that one.
Okay, good morning. Detective, your name?
Detective Corporal Sean Chapaniak, Trenton Police Department.
All right. Yeah, we're going to do a signing on record. Raise your right hand. You solemnly swear or affirm under penalties of perjury that the testimony you'll give in these proceedings will hold true, so help you God.
I do, Your Honor.
All right, go ahead.
On August 12th, 2025, at approximately 0900 hours, Patrolman Stephen K. was dispatched to the Trenton Police Lobby in the city of Trenton, County of Wayne, for a suspicious situation report. Upon arrival, he met with the victim identified as Kathleen Rose Berlinski, 6/19 of 99. Berlinski stated that her ex-boyfriend and co-worker, Henry Franklin Joseph Lent, date of birth 7/19 of 93, sent a video of her giving Lent oral sex to her friend and co-worker, Jordan Page Pletsky, date of birth 6/13 of 95, on August 10th of 2025 at approximately 15:12 hours. Berlinski stated that Pletsky advised her of Lent sending the video on August 11th of 2025 while they were at work at Trenton Corwell Hospital, 5450 Fort Street in the city of Trenton, County of Wayne. She stated that that Lent filmed her giving him oral sex sometimes between January 2025 and March 2025. Berlinski stated that she had dated Lent from approximately November 2024 to March of 2025. Berlinski advised she never gave permission for Lent to share the video with anyone.
All right, based on your sworn testimony, I find that the crime of intentional dissemination of sexually explicit visual material was committed, as well as malicious use of the telecommunications service was committed. There's probable cause to believe those crimes were committed by the defendant. I'm going to authorize the issuance of the complaint and the warrant. And I'm going to go ahead and set an interim bond of $1,000. All right. Thank you very much. Have a good day.
Thank you, Your Honor.
Dan Bennett, 260-702-269. Good morning, Detective. Your name?
Morning, Sergeant Gary Robinson, Gibraltar Police.
Raise your right hand. You solemnly swear or affirm under penalties of perjury that the testimony you'll give in these proceedings will be the whole truth, so help you God.
I do.
Okay, go ahead.
On December 12th, 2025, at 20:40 hours, Sergeant Seifert and Officer Bates were dispatched to 30730 Island Drive for a vehicle crash. When officers arrived, they found a vehicle crashed into the driveway of a parked motorhome. Officers made contact with the driver, who was identified as Amanda Ann Bennett. They smelled the odor of intoxicants, glossy eyes, and she appeared to be intoxicated. Officer Bates ran her through field sobrieties, HGN, walk and turn, one leg stand, which she did not perform well on any of those. She refused a PBT. She was placed under arrest and transported to the station for a intoxilizer test. Once at the station, she refused that. A search warrant was carried out. That was signed by Judge Hessen, and a blood draw was conducted. MSP blood results show her blood was a 0.197. And she has two previous convictions for OWI out of the state of Ohio, 2009 and 2014.
All right. Based on your sworn testimony, I find the crime of OWI third offense was committed. There's a count for OWI third with a high BAC and OWI third. There's probable cause to believe those crimes were committed by the defendant and would authorize the issuance of the complaint and the warrant. And you are all set. Have a great day. Thank you.
Thank you, sir. You too.
Just give me 1 second here. All right. Abdullah Mohammed M. Hawatman, 25B149772A and B. Good morning, counsel. How are you? Good. Nice to see you. How are you, sir? All right. Your appearance?
Yes, good morning, Your Honor. Sharon Payne, appearing on behalf of Mr. Abdullah Mohammed Hawatman for sentencing.
All right. In your name.
Come on, no.
I'm going to ask you to raise your right hand. You solemnly swear or affirm that you will make a true and accurate translation in these proceedings between the court and the defendant. And your state, what do they call it? Not state certified. Well, they've changed all these names, but you certified as an Arabic interpreter, and he speaks Arabic.
Yes.
All right. Sir, what is your name, please? All right. So your client, Ms. Payne, pled to failure to report a property damage accident. That's on count 2, and the leave the scene count 2 was dismissed. He also pled guilty on count 1 to operating while impaired, with the understanding that the operating while intoxicated would be dismissed. Is that all true?
That is correct, Your Honor.
All right, I just need to check one thing if you can give me a moment. All right, so we have victims, and I just want to make sure that they're not out there or not in here. Is there a Jeremiah Riley out there, Heather, or in here?
No, I have no one on Zoom as victims, Judge.
So no victim has appeared. Restitution, if any, will be handled through civil litigation. Have you had the opportunity, Ms. Payne, to review this report with your client? And are there any material additions, corrections, or deletions?
We did have the opportunity to review the report, Your Honor. We have no additions or corrections to report, and we would urge the court to follow the recommendation of the probation.
Okay.
Mr. Hawatman has been attending AA every day, Your Honor, since January 30th, and has presented to myself verification of that. He is taking his sobriety seriously. He has been awarded a restricted driver's license until May of 26, and he's disqualified from the truck driving license, the CDL.
I understand. So he's paying quite a price on that. I get it. Okay. Well, sir, is there anything you would like to say? All right. And you've seen proof he's going every day.
Yes, Your Honor, and I can present that to the
No,
court.
I don't need you to do that. I believe you. 12 months probation, sir. I'm worried about this though. You had an accident, you left the scene of the accident. You got a prior in 2012. You cannot leave the state without the consent of the court. You cannot violate any law or ordinance. You change your address, your place of employment, or home telephone number, you must notify probation. No alcohol, no illegal drugs, no marijuana. You cannot purchase, possess, or consume any one of those. Kratom, poppy seeds, and CBD oils are prohibited. Consuming food or other items containing those substances will be deemed a violation. I want you to attend AANA 3 times a week until you're in outpatient treatment. Once you get in outpatient treatment, you no longer have to attend AA or NA. You're to submit to chemical testing, PBTs, and ETGs as follows: bi-weekly for 3 months. If you're clean, I'll then make it monthly. Serve 5 days jail, credit 1. I'll let you serve the 4 on community service by way of community service. So 32 hours of community service, and I'm going to give you until April 20 to complete that. Pay fines in the amount of $300, costs in the amount of $225, $75 victims' rights fee, $50 justice assessment. The total is $650. You also have to pay a screening fee of $60 for 710. Probation fees of $240 for 950. And then there's an odd figure here, 168. So the total is $1,118, $168 in cost of recovery for a total of $1,118. You may be eligible for early discharge. So if you do everything and there's no violations, in 6 months, you can apply for early discharge. On the third report, 100 fines, 150 costs, 75 victims' rights, $50 justice assessment, 375 for 90 days. I'm not placing you on probation on that case. You have 21 days to appeal. You have 14 days to apply for a court-appointed lawyer for purposes of appeal. Again, if you violate, you could get 93 days on the impaired charge. Any questions, Ms. Payne?
No, Your Honor.
Sir, do you have any questions? Can you pay all of this today? Yes? Okay, you can pay this. Nice to see you. So he's going to go down and pay the fines on these. So it's going to be what, 375 plus the 1,118. So he's looking at $1,493. He's going to pay that, and then he's going to go back down to probation where he'll be instructed. Nice to have you here. Take care. Good luck, sir. Stay out of trouble now. No more. And no contact with the victim either. I did write that on the register, but no contact with the victim. Eric Tarenti Bogaya, Jr., 26F 262289. All right. Where's Mr. Bagaya? Eric Bagaya. Is Mr. Niehenhuis out there? Is Eric Bagaya in here?
You'll call the name off?
I don't know. Where, Heather, was he on Zoom or did he show up?
No, I have had no one on Zoom. I only have our in custody on Zoom.
Call in Mr. Cayley.
Mr. Bagaya looks like he has a retained attorney also.
I know. Can you come on in here, Roger, please? I called this Eric Lagaya Jr., 267-262-2889. Your name, please? Where's the lawyer at?
Oh, he's right here, Judge. Give the discovery form, did you put it in there?
Yeah.
Oh,
I need him and his client in here.
okay, I'll give it to him.
Thank you. And then I'm gonna take that one. That's the case, that's the Zoom with ICE. The guy
Yes,
who's
Judge,
discussed.
but I'm still waiting on his attorney and the interpreter to zoom in.
Come on in here, counsel. You guys joking back there? What? Huh?
I lost track of time, so yes.
All right. Come on up, Mr. Bagaya. Your appearance?
Patrick Knight has P76343 on application, Mr. Bagaya.
Mr. Bagaya, your name?
Eric Bogan.
Is it Bogia?
Yes, sir.
Sorry about that.
I say it wrong every time too, Judge.
All right. What are we, so I signed your order. We're gonna adjourn this a couple of weeks, right?
Yes, Judge.
What do you have, Heather?
We could do Tuesday, March 3rd, or we could do Thursday, March 19th.
You know, lawyers will always take the second day, right? March 3rd would be great. Can you do?
I can't do March 3rd.
Why?
Judge.
Why?
I am flying back from Florida that.
We'll take the 19th, but that's it. If it doesn't resolve, I gotta set it for trial, okay?
Of course, Judge.
March 19th at 8:30, is that good?
That works, Judge.
I may have I'm supposed to start a trial on the 16th. That might bleed over, but shouldn't. So should be done by the 17th, maybe the 18th, but should be done by the 19th.
All right, March 19th, 8:30. If it bleeds over, then I'm gonna have to have you come in the afternoon, okay?
Oh, of course, Judge.
I signed your order. You can go down the hall. We'll give you a copy of the order and you're all set.
Thank you very much, Judge.
Is your client, let me ask a question now.
Of course.
All right, okay, we're good. We're good. Thank you.
Thank you very much, Judge.
All right. Jessica Lynn Anaya. 25R254-240, 25R514-1188. Okay,
Judge, I'm showing a warrant for her. So I'm gonna have somebody pull it.
I'm gonna ask you to throw your gum in that garbage over here, okay? What in the world's going on in this case? What happened on this? Your name? Did you not show up for your pre-sentence report?
I was just here.
I'm not sure what's that?
The 8th, the 5th, one of those days. I was here, and then you had me come back.
I don't know what this is up for, Heather.
I am looking, Judge.
Oh, boy.
I have her scheduled for. I have a pretrial in for today.
See, call you on it more.
I'm gonna have to look at this. I ordered a pre-sentence report on file 25R254240. Did you go and meet with probation when you had when you were in court on February 5th?
No, you just told me to go and get my fingerprints done at the Rockwood.
And I also told you to go over to probation.
No, you didn't tell me I would have went to probation. You just said go down to get a paper to have them for my fingerprints.
I wrote it down. I can't imagine not saying it, but it's possible I made a mistake. Find out from probation what's going on that. I think I'm gonna just send her over there, Heather, if you could just let me know.
Okay, Judge, I do have her file coming down with the warrant also.
Last time you lifted both of those and stuff, good.
If you show up for court, you don't have one.
I'm here on 8.
Listen. I think what's going on.
Okay, I got in. I'm sorry, Judge.
Have a seat. Have a seat. Kayla Renee Florios, 20F234-102A.
Good morning, Judge. The POP 8237A on behalf of the Kayla Florios.
I don't have a defective equipment. Did that go into hang on, did that go into default?
No, Your Honor. So the prosecutor agreed to dismiss the no proof of insurance, and she would be responsible to the defendant.
Yeah, but I don't even have a no insurance file here. She must have paid it or went into default on it. Oh, yes.
Hey.
You know, I mean, I pick up these files and it's like, why are we dealing with the case in 2026 that happened in 2020?
So, Your Honor, there was an address change.
Address change. I'm so sick of hearing address changes. That's all I hear from people. I moved. I forgot. I didn't have a ride. What? I'm not going to go start changing convictions that were entered 5 years ago. I'm sorry. If you want to take this back to him, that's fine, but I'm not going to pull out, have them take out an abstract for no proof. She was in default on it from 5 years ago when she didn't bother showing up, and then set it aside and enter a defective equipment. I'm just not going to do it. I'm sorry. You can take it back to Mr. Cayley, tell him I said that, and you guys can come up with whatever else you come up with, but you need to show up. You know what I'm saying? Yes?
Yes. So not even the allowing?
I'll do the allowing, but I'm not going to change a conviction that's been sitting in her abstract since 2020 or 21. And now have them undo that, add a defective equipment. I mean, she just ignored the court. Address change. You get a ticket handed to you. Address change. What does an address change have to do with anything? Have a seat, young lady. Joseph Michael Lyon, 26B 149926B.
Good morning, Judge. The POP 8237A on behalf of Mr. Joseph Lyon.
Mr. Lyon, your name?
Joseph Michael Arnold.
All right, so does he stand mute, wait formal reading?
Yes, sir.
Not guilty, pleas entered. I'll give him $100 personal bond. You cannot leave the state without the consent of the court. He's another one that didn't show up. I heard this address change thing from him too. I get tired of it. You cannot violate a law. You must appear in court as directed. We can do March 3rd, Heather.
No, this one's a Brownstown case, Judge. So that date, sorry, I lost my sheet here. We can do March 25th.
Okay. So
At 9 o'clock.
That'll give you plenty of time to take care of everything, okay?
Yes.
March 25th at 9 o'clock. I'm giving him a personal bond of $100. Again, you cannot leave the state without consent. You can violate a law. You must appear in court as directed. Do you understand all that?
Yes, sir.
Okay, good luck. Thank you. Go down the hall and we'll give you your notice. Andrew Joseph Ellis Webb, 26B 82402A, B, and C.
The POP 8237A on behalf of Mr. Webb. State your name.
Andrew Webb.
All right, so for purposes of arraignment, does he stand mute? Wait formal reading?
Yes, sir.
Not guilty, pleas entered. Can you tell me what kind of a dog this was?
American Bulldog.
And was this with the, Ms. Patillo, I'm just asking the allegation. Was this dog on dog, dog on person, allegedly, you know? Allegedly.
The judge, I'm not sure.
All right.
Dog's a person. State.
What's that?
Dog's a person.
somebody's arm, and there's photos of somebody's arm that's
Okay,
related. Okay.
I'm gonna give him $1,000 personal bond, but your dog is to remain in your residence. Fenced in area. Okay? In your backyard, I should say, a fenced in area, backyard. Or on a leash. Equipped with a muzzle. And accompanied by a suitable adult. Okay? Do you understand that, sir?
Yes.
All right. No contact with the victim, no contact with prosecution witnesses. You cannot leave the state without consent. You cannot violate a law. You must appear in court as directed. If you want a lawyer going forward, you're going to have to fill out a petition for one. Where do you work at?
I work for Walbridge, Marshall, Michigan.
So you probably can afford your own lawyer, right?
Yeah, yes.
I can't give you a court appointed if you're working. I mean, you're making good money. So I can't give you a court appointed after the first appearance. If you want to fill out a petition, you can, but if you're working for Walbridge, it's very, 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 very unlikely that I'm going to appoint you one. I need a date on this, Heather.
It goes into warrants.
This is for Andrew Webb, correct, Judge?
Correct.
We do have Brownstown also on March 19th. We could do 9 o'clock.
At 9 o'clock, March 19th at 9 a.m. So you go down the hall, get your notice.
Judge, I also want to make you aware, he's neighbors with the individuals that this happening with. I don't think there's any bad blood between the two. So the no contact, I just don't want to set him up for failure because I believe they do communicate.
I'll make it no assault of abusive or intimidating behavior toward the victim. Okay, I'll do that for you. All right. Best of luck. You are all set. And I'm having pleas of denials on the other one. How you doing there, Ms. Heisley?
Good. Thank you, Your Honor. How are you?
Good. Are we waiting on that case out of, is that on the case where ICE has custody? He's in the custody
Yes,
of
Judge.
ICE?
I just brought her in to send her a chat to let her know what was going on. I just
Okay.
called the attorney. We're just waiting on the attorney.
Boy, I hate to ever be late for something like that. They're not going to hold him all day.
That's what I told her office that she needed to call me ASAP.
Right.
Oh, here
What
she
time did
is. She just zoomed in. I'm going to get them all into
Good.
his breakout room.
Good. Okay, perfect. Thank you. All right, just give me 1 second, everybody, please. All right. People against Ethan William Gurriel.
Ready, Your Honor?
255F245-251. Good morning.
Good morning, Judge Attorney John Camilleri on behalf of Gurriel, who is present in the.
This is the parents.
Yes,
You know what you're doing to your parents by doing this stupid nonsense? I'm serious. Your name?
Ethan Gurriel.
Can't be doing this, son. You're not even legally able to drive yet. These scare me. I got an 18-year-old kid here with a 1, 2, 3, and that's a great indicator that you're going to have a drinking problem if you don't already have one. Go ahead. Tell me what you want to say. Is everything in this report accurate?
Yes, it is, Judge. My client and I have reviewed the pre-sentence evaluation. It is truthful and accurate. Judge, I'd like to say a few words on behalf of my client.
Sure.
Your Honor, I would bet on Ethan from this point forward going through life. I would bet on him. I would take him as my own son, and I'm going to tell you why. 4 years, straight A's, letter, sophomore, junior, senior in football. He works at Kroger for 2 years at night, works for the city of Rockwood in the day. He's been doing this for a couple years. He is
got an excellent support group with his parents. He has received numerous academic awards, numerous athletic awards. His past record is the best indicator of his future. I know that this is troubling, but I would consider this a glitch. I would consider this a fluke. His parents have been in my office 3 years. He seems to have congealed. What
do you mean 3 years?
Pardon me?
What do you mean 3 years?
3 years he's been working?
I thought you said his parents have been in my office.
No, 3 times. I'm sorry.
I'm sorry.
I'm
Okay,
sorry.
okay.
Judge, when he sits with his parents, I can just tell he has the utmost respect. I see so many young kids, they don't want to learn from adults. They're almost like you're harassing them when they are being told things and instructed. I've had the perception that before me, he is completely comfortable with his mom and dad. And that indicates to me that he's been raised well. Judge, you indicate you wanted him to go to AA. He's been to AA 5 times. Your Honor, today he tells me no one told him to do this. He's been to counseling 3 times locally. So I'm empathetic about his future. I'm understanding. I know the pressure that they are under. It's not legitimate, but this young man has performed not because he knew he was going to be in court February 19th, 2026, 2, 3, 4, 5 years ago. He's been performing stellar because he knew he had a future. It was in his heart to perform. He's got great study habits. You don't get those type of study habits because you're going to go to court 2026 and impress a judge. You get those or you perform that way because it's inert in you. It's who you really are. So those type of grades, that type of behavior, it is not fabricated to impress a judge. But I can tell you, we cannot ignore it. So I am concerned. I've had very sincere conversations with him about the junctures in life, the times in life, 8, 9, 10, 12 years from now, whether you're going to go left or right at that moment. I think he's going to make the right decision. So we've read the recommendation, Your Honor. I wanted to say these things because I know you're not aware of them. His performance. I bring up the athletic and the academics because I kind of lived that life. My two, we both went to law school, except we know how hard it is. He's going to perform just as well in that environment. Your Honor, we ask you to adopt the recommendation. We do believe it's fair. I know he's underage. I wouldn't expect you not to give him 10 months of probation. He's paying back his parents for all the expenses. Judge, and just one last thing. He's going on vacation with his mom and dad. They're going March 26th through April 5th. They're traveling as a family. They are going out of the country. They've already purchased way before this case even started.
Where are they going?
They're going to Mexico. I can't let his prior performance go unnoticed to your we're asking the court.
I'm not going to say he can leave the state to go to Mexico. I am saying he can leave the state between March 26th and April 5th. It scares me when we start going to other countries. You get a drunk driving, you can't even go to Canada. I'm not going to be responsible for somebody not being able to get back here. I don't have a problem with him leaving the state, but you guys are going to have to check on whether there's going to be any issues. You got it?
I didn't hear the last part. I got to check on.
You got to make sure that there's not going to be any issues. I don't think there is.
Right.
But I'm not going to say somebody can leave the state to go to Mexico and then have somebody tell me he got detained in Mexico because he's on probation here. I just don't get into that, you know?
I understand.
So I'll let him leave the state between those dates of March 26th and April 4th, I think you said, right?
Yeah.
I'm saying till the 5th.
Yeah.
So, all right, well, okay.
So there's some mitigating factors in all of this, not about the event, but his
That,
path
you
going
know,
forward.
and I don't want him to make, he looks scared to death, and I don't want you to be scared. You're not going to jail today, okay? That's not the issue. If you're doing that well, you're risking your future by doing things like this. I'm just telling you. You go to law school, I'm not saying you're going to go to law school, but if you did, you're going to be answering about this. You're going to be answering about this in 7 or 8 years. And that's what bothers me is when young kids don't understand there's real consequences to their actions. I don't want you to go home and think you're a bad person. You're not a bad person. But you got to make sure you don't do things like this. Your parents would have been glad to pick you up.
Yes, Your Honor.
You know what I'm saying? That's the thing about it. That just, all right. What are you going to do next year?
Go to college or trade school.
All right. Do you want to say anything here?
Yeah, I apologize for my behavior. It's been a large learning lesson and won't happen again.
All right. Just relax. You're all right. Okay? It's 12 months probation. You cannot leave the state without the consent of the court. You cannot violate any law or ordinance. If you change your address, your place of employment, or home telephone number, you must notify probation. You have to report as directed. No alcohol, no marijuana, no illegal drugs. You're going to submit to chemical testing, PBTs and ETGs. I'm going to make it bi-weekly for 3 months. If you're clean, I'll then make it monthly. No kratom, no poppy seeds, no CBD oils. Those are all prohibited. Consuming food or other items containing those substances will be deemed a violation. I want you to go to AANA at least once a week until you're in outpatient treatment. Once you get in outpatient, you don't have to attend AA or NA. Attend the Victims Impact Panel. Again, subject to what I said, you can leave the state between March 26th and April the 5th. I just can't justify community service under these circumstances. 4 days jail credit, 1, serve 3. I'll let you serve those on our court work program. 3 days court work. There's a $35 a day charge for that for a total of $105. Okay. You do all this, you're eligible for early discharge. You could be off probation in 6 months if you do everything, and you don't have any violations within the preceding 90 days. So you can apply after 6 months if you've got everything done. Fines $300, cost $200. We go a little light. You're a kid. 75 victims' rights, $50 justice assessment, 6 1/4. Screening fee $60 for $685. Probation fees are $240 for $925. You have cost of recovery of $150. That makes $1,075. But you do have your court work program fees, $1,180. If you violate, your probation could be revoked. You could be incarcerated for 93 days. You have 21 days to appeal and 14 days to apply for a court-appointed lawyer for purposes of appeal. You have the right. I mean, I don't need your parents to pay this. I'd almost rather set you up on a payment plan. You got me? Whatever you want to do.
It could be paid today. It can be paid today, Judge. I went over
He's going to pay them back. Listen, don't, you know, you look like you seem like a nice kid. I shouldn't say look like one. You seem like one, and I can tell you're torn up, but you're going to be fine. Just don't do this again. This is the last criminal contact you should have. You understand?
Yes, Your Honor.
All right. Okay. So I'll pay it now. I'll meet with probation. I really wish you well. Thanks for coming, you guys. That tells me a lot.
Thank you, Judge.
Thank you. All right. Are we ready with, you tell me when I'm going to call these other ones, Heather. I'm sorry, the case with the gentleman in custody with Ms. Medina.
Okay, they're all in the breakout room with the prosecutor.
Okay, that's fine. Kayla Renee Florios, F234102A. So,
Judge,
yeah, I don't mind this. I want you to understand. I'm not, if this was 3 months ago, that'd be a little different. Okay, your appearance?
Dion, TOP 82378, on behalf of Kayla Florio.
All right, so your name, ma'am?
Kayla Florio?
So she's going to plead to allowing an unlicensed driver to drive, but no proof of insurance will stay in effect, and the suspend will be dismissed. True?
Yeah.
If you do that, young lady, the possible penalties here are up to 500 fines, 90 days jail. Costs are all those. Do you understand that?
Yes.
And did you sign, read, and understand the advice of rights?
Yes.
If you plead guilty, you'll be giving up all those rights, and we're not going to have a trial. Do you understand that?
Yes.
You charge allowing an unlicensed driver to drive. How do you plead?
Guilty.
Were you in control of a motor vehicle, a 2008 Ford that was being operated on Deer Creek Drive
Yes.
near North Aztec Circle in Flat Rock, October 6th of 20?
Yes.
And you allow somebody to drive that was unlicensed or suspended or revoked, and was that you?
Yes.
Are you on probation or parole?
I know the difference.
Well, are you on probation to any court? Do you
Oh,
have,
am I on it? Oh, sorry, no,
and you've not been convicted of a felony?
No.
Anybody force you to plead guilty?
no,
Please accept it.
yes.
The suspend's dismissed. All right, counsel, what do you have to say? Anything?
Yes, Judge, she is employed. She has 2 kids. She is eligible to get her license back. She just has to walk into Secretary of State. You get it. I think she may have to pay a reinstatement fee, but she is eligible to have her license.
And she posted a 2,010% bond. So she posted 200, so 180 of that will apply.
Yes.
Okay. Anything else, young lady, you want to say?
I'm sorry, it doesn't even have to do.
100 fines, 115 costs, 75 victim choice fee, $50 justice assessment. Attorney fees are 40, totals 380, or 60 days in jail. Okay. So, 380 or 60 days, you have 180 to apply. Do you have the other 200 or not?
Yeah, I can get it off.
All right, you pay it all now when you're all set, and I wish you well. Good luck. Don't be doing this and ignoring courts again. You want to agitate a judge, at least this one. You do that kind of stuff. I'm serious. Good luck.
Thank you. Thank you, Judge.
Thank you. Do I have Diamond Gee here? All right, come on up here, man. This is people against Diamond Mercedes Geese, 22B 141007. Your name?
Diamond G.
I am sorry. I know. All right. Why weren't you here on February the 3rd, young lady?
I have like a follow-up with the email. I didn't think it was, she didn't show me, so. But she said something.
I'm going to go ahead and arraign you on the charge. I'll give you a lawyer if you want. You are charged with violation probation. They think that you failed to pay your fines and costs as ordered as set forth in count 1. You understand the charge?
Yes.
Count 2, you failed to attend, or I'm sorry, failed to provide written verification attending and completing outpatient treatment. Say that you failed to attend treatment as recommended. Do you understand the charge?
Yeah.
You have 9 prior technical violations, which means you could be incarcerated on this for the maximum provided by law, which is 93 days. Do you understand that?
Yeah.
Did you sign, read, and understand an advice of rights form here?
Yes.
If you plead guilty, you'll be giving up all those rights, and we're not going to have a hearing or a trial of any kind. Do you understand that?
Yes.
All right. I'm going to give you a lawyer, okay? We're going to give you a lawyer unless you tell me, Judge, I want to represent myself. That's up to you.
I have one.
Who was it?
I have no idea. She didn't check in on me, so.
Just saw you guys sitting.
Who was it? What do you look like?
He has a haircut. I'm sorry.
I have a haircut too. It
Judge,
wasn't me.
it might be our MIDC, which I believe might be Corey today.
All right. We'll find who your lawyer is. I'm entering a not guilty plea. All right.
Thank you.
And then when he's ready and you're ready, we'll go from there.
Okay, thank you.
All right, so I have a warrant on 2-5. Heather, I want you to work me through here with Jessica and Naya, please. I have a 25R514249, a warrant for failure to appear for a show cause on February the 4th. And then she was supposed to be here for a pre-sentence report, it looks like, I think, on February 5th. It looks like I took a plea to something, but then it got scratched out. I don't know what happened on that. And then the other case was taken under section 771.1, and I'm talking about 25R514118A.
Yeah, that one's a probation case.
Yeah, but which does she have a probation violation? Oh, she didn't appear on that until February 5th. Call in. Jeez. Do you know what happened on 25R514?
No, now that I'm looking, I'm a little confused too, Judge.
25R. Let me call in Mr. Pellin. I'm interested in what happened on 25R254240. I don't know what happened. I wrote down the date.
Jim Pollard?
Hey, Mr. Pellin, can you come in here again, please? I got a question on a case.
Yep.
Thank you.
It looks like it was pled down, I see, to disorderly on that one.
And I ordered a pre-sentence report. But I don't know.
I'm thinking maybe I had an error. And then did you schedule for sentencing today? And I might have in error put pretrial instead of sentencing.
PSI sentence, but I didn't write down a date. So I have a feeling the plea didn't go through. We'll check.
I did put in today's date and I did amend it down to the disorderly. So I would have thought the plea would have went through.
I've called in Mr. Pelland. I'm going to see what he can remember of this.
Because I did put in conditions that you told her too on February 5th. I have conditions in JIS.
Yeah, I arraigned her on February 5th. And then she pre-tried it looks like.
Mm-hmm.
And there's a stip form in here. And I obviously wrote on here, it looks like there was going to be a plea. And I said no, or didn't, or there was no factual basis or what have you.
And then Judge, when we're done with this, it looks like they're all coming out on the in custody case.
Oh my gosh, and thank you so much, Heather. Since it was tentative, I again will never do that again. It
file
should
on
have been
that?
on there.
You're
Yeah.
fine.
Do I have the file on that?
No.
Who has the file on this case with ICE or whatever? What? Okay, all right. You have this case
Which one, Judge?
with?
Yes, right here.
Hi. Jose Gabriel Rodriguez Medina, 25F245235. All right. I'm going to ask you to state your name, Ms. Heisley.
Shalonda Heisley, interpreter for Spanish.
Hold on, he's stuck in the breakout room. I'm trying to get him out.
Okay. Jim, take a look at these and go talk to Heather on Jessica Payne. I don't know what happened. There was something on February 5th. It looks like you wrote up a disorderly under 771.1, and for whatever reason, it probably didn't go through. And she's got a new warrant. And can you go down to Heather and take a look at it, especially hey guys, can you take a look And see if that brings back a recollection, the one on February 5th, please. The one there's a stip form in there that you pled, that you had disorderly, and it looks like I wrote something down and scratched out everything, so I don't think the plea went through.
Disorderly on 771, maybe?
I don't know, like, initially, I'm gonna probably have to have her check. Have Sadie check her, see if you can figure it out. Thank you.
Does she have an attorney? Is there an attorney?
I don't know. Did she have an attorney? I'm gonna give her one.
Yeah.
I'll get her one. All right. Do we have the gentleman out?
There he is.
I'm gonna call the case again. It's people against Jose Gabriel Rodriguez Medina. Ms. Heisley, your name again, please.
Shalonda Heisley, interpreter for Spanish to English, English to Spanish.
I'm gonna ask you to raise your right hand. You solemnly swear or affirm under penalties of perjury that you will make a true and accurate translation in these proceedings between the defendant and the parties involved.
Yes, Your Honor.
Okay. Ms. Medina, your name, please.
Señora Medina, su nombre, por favor.
Crystal Marie Medina. Crystal Marie Medina, Your Honor, on behalf of Mr. Rodriguez Medina, no relationship, Your Honor, and I would ask my client to state his name again for the record.
Mi nombre es Cristal Marie Medina, representando José Rodríguez Medina. No estoy relacionada con señor Rodríguez Medina. Por favor, señor, diga su nombre en voz alta para que conste en actas.
José Gabriel Rodríguez Medina.
All right. So for purposes of arraignment, Ms. Medina, how does your client wish to proceed?
Para el propósito de la lectura de cargos, señora Medina, ¿cómo quiere proceder su cliente?
Your Honor, we would waive formal reading and stand mute.
Su señoría, vamos a negarse la lectura formal de las acusaciones y mantenernos en silencio.
I will enter a not guilty plea for purposes of arraignment.
Voy entonces a entrar una declaración de no culpable por el propósito de la lectura de cargos.
Now, as I understand it, defendant is now going to plead guilty to operating while visibly impaired. Is that true?
De lo que entiendo yo, demandado va a declararse culpable a esta acusación modificada a conducir bajo los efectos de alcohol, ¿cierto?
That is correct, Your Honor, and I would like to note for the record that my client was able to consult with his immigration attorney with regards to any immigration consequences relevant to this plea, Your Honor.
Sí, eso es cierto, su señoría. También quiero anotar que mi cliente tenía la oportunidad de consultar con un abogado de inmigración para entonces saber todas las consecuencias que tiene que ver con esta causa.
If you plead guilty to operating while impaired, Ms. Medina,
si usted se declara culpable,
the operating while intoxicated will be dismissed.
Entonces vamos a sobreseer lo de conducir. What was that on charge, Your Honor?
Operating while intoxicated will be dismissed.
Entonces vamos a sobreseer y desacatar lo de conducir bajo los efectos.
Possible penalties are as follows: up to $300 in fines.
Los posibles penalidades son hasta $300 en costos.
93 days jail.
Hasta 93 días en el cárcel.
360 hours of community service.
Hasta 360 horas de servicio a la comunidad.
Court costs are all of those.
Y los costos de tribunal y o todos de estos.
4 points will be added to your traffic record and your license would be suspended or revoked in accordance with your record.
Y también tenemos la posibilidad de revocar la licencia de uno o suspenderlo y poner 4 puntos en el archivo de conducir de uno. ¿Usted entiende todas esas posibilidades?
Do you understand all that, sir?
¿Entiende, señor?
Sí.
Yes.
And I know what your lawyer just said, but I need to tell you as well, there could be immigration consequences as a result of this plea and conviction.
Yo sé que su abogada acaba de decirle a usted, pero tengo que repetirlo, señor. Usted entiende que pueda tener consecuencias inmigratorias a lo de declararse culpable en esta causa. ¿Entiende eso?
If you plead guilty to operating while impaired, you'll be giving up your right to a trial of any kind.
También, si se declara culpable, está negando su derecho a un juicio.
Your right to remain silent, your right to cross-examine their witnesses,
y su derecho a mantenerse en silencio, su derecho a contrainterrogar testigos contra uno.
Your right to bring in your own witnesses and use the subpoena powers of the court to bring in those witnesses.
También está renunciando el derecho de uno para llamar testigos a venir a representación de uno o usar el poder de tribunal para obligar a esas personas a venir a testificar a su favor.
You would be waiving your presumption of innocence.
También se niega, I'm sorry, Your Honor, go ahead.
And waiving the requirement that they prove you guilty beyond a reasonable doubt.
Uno niega su derecho a estar considerado inocente hasta que se le puede encontrar culpable más allá de una duda razonable.
We are not going to have a trial if you plead guilty. Do you understand that?
No vamos a tener un juicio si usted se declara culpable. ¿Entiende eso usted?
Sí.
Yes.
And you will be giving up all the rights I just enunciated. Do you understand that?
Y también está renunciando todos los derechos que le acabo de mencionar. ¿Lo entiendes?
Sí.
I didn't hear you, Ms. Heisley. I'm sorry.
Yes.
You can... Okay.
Yes.
To the charge operating while impaired, how do you plead, Mr. Medina?
Entonces, este cargo de conducir bajo los efectos, ¿cómo se declara usted, señor Medina?
Culpable.
Guilty.
Were you operating a motor vehicle on November 26th of 25 on Telegraph near Van Horn and Flat Rock at 6:44 p.m.?
¿Estaba usted manejando un vehículo el 26 de noviembre de 2025 por las calles de Telegraph y Van Horn a las 6:44 de la noche en la ciudad de Flat Rock?
Sí.
Yes.
Prior to that, did you drink alcohol? And if so, what did you drink and how much?
Y antes de conducir ese vehículo, ¿usted consumió alcohol? Y si así es cierto, ¿cuánto alcohol consumió usted?
Sí lo hice.
Yes, I did.
Y en la mañana, en la mañana, no recuerdo exactamente la hora, me tomé 3 cervezas.
I did. And in the morning, I did drink some. It was around 3 beers. I don't remember the time exactly.
Ya, pero fue en la mañana antes de las 1 de la tarde.
It was in the... Sigue.
Y un shot de un licor que no recuerdo, que era algo pequeñito. No sé si me ven, pero como así.
So that was in the morning before 1 p.m. And then I also had a shot of some alcohol, some liquor, but I don't remember the name of it. It was about this size, if you can see my hand.
I can't see your hand. I see. Okay, so you're saying a regular, okay, wait a minute, do that again.
Otra vez con la mano, señor.
All right, so it's probably 2 or 3, the equivalent of 2 or 3 alcoholic shots. Is that fair to say?
Equivalente, señor, a 2 o 3 shots, ¿verdad? En ese tamaño.
2 shots, sí.
2 shots, yes.
Was your ability to operate the motor vehicle impaired because of the alcohol consumption? And if so, in what way?
Entonces, debido a tomar esas bebidas, ¿estaba empeorado su manera de conducir el vehículo? Y sí, ¿de qué manera? Si puede explicar.
Se puede decir que sí me afectó un poco al momento de manejar.
It did affect me a little when it came time to drive.
Why were you pulled over?
¿Por qué le orillaron?
Your Honor, there was an indication that he was swerving and crossing lanes, so I would ask specifically about that.
Su señoría, había indicaciones que él estaba cruzando la línea al manejar, entonces haría las preguntas en cuanto a eso.
Was the vehicle swerving due to your alcohol consumption?
Entonces, ¿estaba manejando de un lado a otro vehículo debido a su consumo de alcohol?
Pues se puede decir que sí, pero...
Okay, I think that's, he said, well, go ahead.
Yeah, well, I think so. Yes, that would count.
Pero,
all right. You took a blood test at the hospital, correct?
Usted tuvo un análisis de sangre en el hospital después, ¿cierto?
Sí.
Yes.
Ms. Medina, were the results of the blood draw 0.193, and do you stipulate that that was an accurate reading for purposes of the plea?
Señora Medina, era el resultado 0.193 y era cierto tanto que podemos usarlo aquí como indicación.
Realmente,
So
realmente fue lo
stipulated.
de lo que no tuve
Sir,
conocimiento.
they were asking me.
Señor, estamos preguntando a la señora Medina, la abogada.
Como dice el señor Medina, disculpe.
Sorry, Your Honor, he misheard me. He thought I said Mr. Medina when I said Miss Medina.
And so stipulated, Your Honor, so stipulated.
Are you on probation or parole right now, Mr. Medina?
Señor Medina, ¿está usted bajo libertad condicional?
No.
No.
Anybody force you to plead guilty?
¿Alguien le obligó a tomar esta decisión de declararse culpable?
No.
No.
All right. Well, I'm going to accept your plea to operating while visibly impaired.
Entonces voy a aceptar su declaración.
I'm going to dismiss the operating while intoxicated.
Voy a sobreseer lo de manejar bajo los efectos.
By law, we have to do a screening and assessment. John, tell probation I'd like them to hop on as soon as they can.
Okay.
You tell them this is the gentleman under Rice custody, please.
Entonces, por la ley tenemos que hacer una evaluación inicial y una evaluación.
I'm going to give you a personal bond of $1,000.
Le voy a dar una fianza personal de $7,000.
No alcohol, no marijuana, no illegal drugs.
No puede consumir alcohol, no puede consumir marihuana y tampoco cualquier droga o sustancia ilegal.
You cannot leave the state without the consent of the court.
No puede salir del estado sin permiso del juez.
You cannot violate a law and you must appear in court as directed. You understand all that?
Y no puede quebrantar ningún ley y tiene que comparecerse en cualquier audiencia que se le indica. ¿Entiende eso usted, señor?
Una consulta. ¿De cuánto era la multa? No alcancé a escuchar. Sí.
And I'm sorry, how much was the fine? I didn't hear you. How much is the fine?
Sentenced you. I'm not sentencing you today. Probation is going to interview you with Ms. Heisley's assistance, and I'm going to try to expedite that.
En este momento no estoy dando sentencia, señor. Primeramente va a recibir una entrevista con la ayuda de la intérprete para determinar cómo vamos a proceder.
And we are going to give you a sentencing date that we have to make sure we have the ability to connect with them again. And Ms. Medina, well, I can do it whenever you guys want. This is not a